All right, welcome to the docket. I'm your host, Bob Mata, and I'm joined by my beautiful, brilliant co-host, Allie. What's up, girl?
Hey, babe. Hey, y'all.
What's up, guys? How you doing out there, guys, gals? And I always use guys in a genderless way, just so you know. So we are continuing our coverage of the people of the Commonwealth of Massachusetts versus Karen Read. If you're not familiar with that case, here's a real quick thumbnail. It's essentially, you've got a woman, Karen Read, who is dating a former Boston police officer, John O'Keefe. They go out for a night of hijinks and hilarity, drinking with friends. It ends up that they're going to go to an after party at another friend's house. Karen Read drops him off, or at least that's what the story is. And the next morning, John O'Keefe, unfortunately and tragically, is found dead on the lawn of 34 Fairview, which is the home of the friend's house that he was supposed to go to, or the yard of the friend's house he was supposed to go to. So subsequently, she gets arrested, first charged with manslaughter, but then gets upgraded to second-degree murder. So we are currently in trial. There are two prevailing theories. The state's theory is that in a fit of rage, Karen Read ran him over and killed him, or in the alternative, was doing a three-point turn and accidentally hit him. The defense's theory is that something went on in that house, that John O'Keefe went in that house, something happened in there, and that he was drug outside, unconscious, and left to die. And that's where we're at. And we are, I think, in week 5. We're on day 21, just completed today. Day 22 starts on Monday because the courts are dark tomorrow, or that courtroom's dark at least. And where we're at right now is what I consider to be, out of all the witnesses, kind of the watershed witness for the Commonwealth thus far, which is MSP Trooper Sergeant YURI. How do you think you pronounce his name? BUKHENIK? I've been going it, but I mean, Alan Jackson, who's one of the paid attorneys, is butchering the guy's name. So I'm going to go with BUKHENIK, or BUKHENIK. Not exactly sure how to pronounce it.
BUKHENIK, maybe.
Or I could just call him YURI. That's what a lot of people seem to do. What do you got going on there? What's that? It sounds
me?
like it's me. I got something happening.
Oh.
You guys can't hear that though, right?
I don't hear anything, but I don't have my headphones on.
All right, good. So we're going to do a couple things tonight. We are going to cover both the direct as well as the shortened version of the cross-examination, as that was cut short today because obviously it was a half day. And Jackson was, I don't know if he was just getting started, but it seems like there's plenty more to go in that. But we do want to cover the direct because the Commonwealth used BUKHENIK as a major force from the state troopers in terms of getting evidence in.
And as the expert of everything.
He did seem to know a lot. Jack of all trades, master of none, I think is a fair way to describe him. So what I think we should do first, Allie, is go through the document. So I'm going to go ahead and pull that up. And if y'all are not aware, this was a filing that happened very recently, wherein the Commonwealth is seeking to exclude the defendant's expert, Dr. Marie Russell. So, and if you're new to our channel, typically what I do is I will read through the document so that y'all understand what we're going to be talking about, because we feel that it's education. We feel that it helps you have a better understanding, and we'll translate it as we go. So this was filed on the 6th, I believe. It looks like it was filed on the 6th by Lally. On April 15th of 2024, the day prior to trial, the defendant provided the Commonwealth with a witness list, which contains the names of civilians, police, defense investigators, and experts. On April 22nd of 2024, the Commonwealth filed the Commonwealth's renewed motion for reciprocal discovery and renewed request for voir dire of any proposed defense experts. And that's in quotations. So reciprocal discovery means it goes both ways. Okay, so that's all it means. It means that both sides have an obligation to turn over discovery to one another. So during that week of jury impanelment, the defendant was ordered to comply within 1 week with Mass R Sim Pro 14, or criminal procedure. On April 29, 2024, opening statements were made and the trial testimony commenced. The defendant sporadically provided reciprocal discovery to the Commonwealth on May 1 and May 7 of 2024. See Commonwealth v. Reynolds, which Ali is pouring through right now. A defendant's discovery, which cites in part, a defendant's discovery obligations includes impeachment evidence, quote, allowing the defendant to withhold such evidence against a witness who is certain to be called to testify, which would undermine the discovery rules and allow attorneys to return to trial by ambush. Theatrics do not accord with our discovery process, end quote. The defendant has failed to comply with Mass Rule of Criminal Procedure 14A6, which requires the defendant to produce all intended expert opinion evidence, including all written reports and opinions that pertain to this case and the identity of anything upon which the expert bases their opinion. All right, hold on. I want to get my view right. Enable my scrolling. All right. So he then cites the rule 14A1 provides for an automatic exchange of discovery regarding intended expert opinion evidence. The Commonwealth again renews its motion for reciprocal discovery. On April 15th of 2024, the defendant identified Chris Van E., PhD, as a potential expert witness in biomedical and mechanical engineering. The defendant proffered that, quote, Mr. Van E. will testify regarding his opinions and conclusions regarding the Commonwealth's reconstruction and the EDR data obtained in connection with this case, which I cannot wait for. He will testify to the chronological data derived from the EDR, including key cycles and triggering events from the time period in question, end quote. However, this description fails to comply with Mass R Crim 14A6, which requires the defendant to disclose the opinion rendered, all intended opinion evidence, and any reports prepared by the expert. The defendant also identified 3 experts from ARCA or ARCCA LLC, which is Daniel Wolf, PhD, Andrew Rentschler, PhD, and Scott Klein, BSME, as expert witnesses in accident reconstruction. The defendant indicated that each expert will, quote, testify consistent with report in possession of the Commonwealth, end quote. Pursuant to 14A6, the Commonwealth again moves for the defendant to produce all written reports and opinions that pertain to this case and the identity of anything upon which the expert bases his opinion. The Commonwealth also moves for the defendant to specify which each of the 3 experts did, what their independent opinion is, and what each expert would testify to. Furthermore, a voir dire is necessary to determine whether each of these 4 proposed experts are qualified to render an opinion about crash reconstruction, whereas all 4 proposed experts are biomechanical engineers and not crash reconstructionists. Wow, you hear the hound?
You must see something outside.
Squirrel. On May 21st, 2024, the defendant provided the Commonwealth with the CV of Dr. Marie Russell, an expert witness not previously disclosed. Herein lies the rub. This is what the real issue is. On May 30th, 2024, during the 6th week of trial, Attorney Little provided the following synopsis about Dr. Russell. She has reviewed the autopsy photos, grand jury testimony of Dr. Scordi-Bello, the entirety of the autopsy report, all reports associated with Chloe's prior bite history, photographs of the items in evidence, and the UC Davis DNA results and evidence submission forms.
So that complies with probably the first part of the rule to say everything that the expert relied on and what they reviewed.
Right. She is expected to be called with focused testimony related to the right arm injuries sustained by Mr. O'Keefe. Dr. Russell will testify that the wounds and injuries on Mr. O'Keefe's right arm are consistent with an animal attack, namely teeth or claw marks, or a combination of both from an animal. She will also testify that these injuries are inconsistent with having been struck by a vehicle, road rash, or scratches from broken glass or taillight material. She will base her opinions and conclusions in part on having treated hundreds of patients in the ER with injuries sustained from animal attacks, including dogs. No written report or opinions from Dr. Russell were provided. So, I mean, just on the face of it, in terms of discovery, like you said, they basically gave a recitation of what she relied on forming an opinion, and then gave her opinion. So both things are there.
Right, but didn't they say that this was like late? It was
late. It was way late. It was deep into trial. They never heard of her. The Commonwealth never heard of her until after the jury is impaneled, which means that jeopardy is attached. Double jeopardy is, So a criminal defendant's constitutional right to call a witness on her behalf is not absolute and may be limited. In the judge's discretion, in the face of legitimate demands of the adversarial system, Commonwealth v. Dranka, the defendant filed the notice of experts 1 day before trial on April 15th, 2024, and for Dr. Russell on May 21st, 2024, with a synopsis of her opinions over a week later on May 30th, during the 6th week of trial, for violations of Mass Rule Crim Procedure 14. A judge may, in her discretion, bar these witnesses from testifying, citing Dranka again. This sanction may not be imposed without a judge's balancing the Commonwealth's interest in enforcing its procedural rules against the defendant's constitutional right to present evidence on her behalf. Factors in assessing such a balance include 1, the prevention of surprise, 2, evidence of bad faith, 3, prejudice to the Commonwealth, 4, the effectiveness of less severe sanctions, and 5, the materiality of the testimony to the outcome of the case. And then he cites various cases, Commonwealth v. Durning, and then Commonwealth v. Chappie. So the Commonwealth moves to exclude Dr. Russell's testimony as the Commonwealth is prejudiced by the extremely late notice of Dr. Russell. The Commonwealth has called over 50 witnesses thus far, and a request for a continuance 7 weeks into trial is impractical. In addition, jeopardy is attached. The Commonwealth is furthermore prejudiced by the defendant's decision to elicit this testimony and the surprise it has caused. During a final pretrial hearing on February 15th of 2024, when asked by the court whether there was any dispute about a canine's involvement or canine DNA, Attorney Yannetti indicated, quote, no, and the defense was not pursuing such a claim. It was not until April 29th, during opening statements, where, contrary to the court's prior ruling that third-party culprit evidence was not admissible or appropriate for opening statements, that Attorney Yannetti unfairly prejudiced the Commonwealth by arguing that, quote, Karen Reed was framed. Her car never struck John O'Keefe. She did not cause his death. And that means that somebody else did, end quote. And then, surprisingly, proceeded to claim that the defendant's injuries were consistent with the dog attack. In light of this, on May 15th, 2024, the Commonwealth called Terry Kuhn, a forensic scientist, to testify that there was no canine DNA present on the samples provided to her veterinary forensic laboratory. Footnote 1, due to personal reasons of Ms. Kuhn, an out-of-state witness, she was unavailable after May 16th, which is why they had her testify out of order. So Ms. Kuhn did not render an opinion about the cause or appearance of John O'Keefe's injuries, nor offered any testimony about whether John O'Keefe's injuries were consistent or inconsistent with an animal attack. The Commonwealth is unduly prejudiced by the defendant's intentional delays in providing appropriate discovery and notice to the Commonwealth. See Reynolds. Bad faith when failure to provide discovery is deliberate and willfully motivated by desire to obtain a tactical advantage that would minimize the effectiveness of cross-examination and the ability to adduce rebuttal evidence. Furthermore, the proposed testimony of Dr. Russell may necessitate a Daubert Lanigan hearing where the defendant bears the burden of establishing that the proposed testimony would assist the trier in fact, and that the methodology underlying the expert testimony is sufficiently reliable. The trial judge must also determine whether the witness has sufficient knowledge of the facts and expertise to render an opinion. Of note, Dr. Russell's expertise is with treating patients in an emergency room and how injuries may appear on living individuals rather than how injuries are depicted on a deceased male and in a post-mortem photograph. As for the experts disclosed on April 15, 2024, the Commonwealth again moves in order that the defendant produce the appropriate proffers, opinion evidence, and expert reports forthwith so the Commonwealth can adequately prepare for cross-examination. As to Dr. Russell, the Commonwealth moves for an order to exclude her testimony entirely, as there is no less severe sanction to ameliorate the surprise, the bad faith, and outrageously delayed disclosure. The Commonwealth bears the burden of proof and production at trial and cannot try the case while simultaneously working to understand and rebut testimony from experts whose reports and opinion it does not have, without which the Commonwealth is prejudiced and unable to effectively prepare for cross-examination of these witnesses. Signed, Laura McLaughlin.
So the case that they cited to Reynolds, that's a situation where this one doesn't particularly involve an expert, but it outlines what the judge has to find in order to actually exclude a witness. So that case involved a situation where the state called a witness who testified that it was a snitch, jailhouse snitch, who testified his sole motivation for testifying and for helping was, justice. And the defense had some letters and some transcripts from some other proceedings where he was requesting assistance in those proceedings for his information. So I think somewhat surprisingly, they found that there was an order that said all witnesses and that they had to include impeachment evidence, and that defense said that they didn't turn it over deliberately. I mean, how do you know a guy is gonna lie? I mean, but this is what the court held. But in my mind, how do you know a guy is gonna lie? And you have to let them know, don't let him lie, because I know if he lies, I got him dead to rights. But in any event, he had to turn it over. But the court went on to say that, the exclusion of a witness, especially in a murder case, is the most extreme, and it can only be saved for the most egregious situations. They called it hardcore transgressions. So this is not that, like, I don't think this is going to be deemed like deliberate in the sense that in Reynolds, it was deliberate because they were like, we want to catch him in a lie. And even in that case, the court said at retrial that the defense can impeach the witness with that evidence, and the state can try to rehabilitate. In this situation, excluding a witness altogether would be extreme. I don't know what he's referencing there, maybe taking Yanetti's statement out of context, because anyone who's paid attention to this case knows that they have always been alleging, they, the defense, that the markings on John O'Keefe's arm is from a dog. So, and that's on them, that they called a witness and said, well, he made this statement in opening, so we called this witness, and then she didn't opine on anything related to this, so now we're screwed. They've got rebuttal. They've got the opportunity to be, someone in there. They know what she's going to say, trying to find someone to, help them with the cross-examination at this point, and then they get their time for rebuttal. So we'll have to see. I'd be surprised if everything's exactly the way that the state's like poising it as, because it just seems surprising that this defense team would like completely violate the rules without any sort of explanation, or, well, we did this. And I think there was something in the rules in the Commonwealth that didn't trigger reciprocal discovery until a certain portion after the state gave their discovery. I kind of remember that being an issue, like, well, they didn't turn theirs over, so now we know that our obligation kind of kicks in. So we'll just have to see where this goes, but I'd be surprised if she, completely.
Yeah, I think there's a workaround. I think that Lally's being completely disingenuous. Everybody and their mother knows that the defense believes that Chloe or a dog caused those injuries to John O'Keefe's arm. For him to say anything other than that, he's completely full of shit. I mean, it's been argued in motions to dismiss. It's been out there. Notwithstanding that fact, I believe that Lally is not fudging on the dates. I'm sure that this is going to boil down to, does Judge Cannoni have a less severe remedy? Because when
It
you're
also does come down. I did just check the reciprocal discovery rule in Massachusetts, and that kicks in. It says, following the Commonwealth's delivery of all discovery required pursuant to another subsection, that's when the defendant's obligation kicks in. So who knows? The defense may respond with, well, they didn't give us their, expert information until closer. We know there's a lot of things they said they didn't have, that they didn't have yet. So,
well, isn't that a two wrongs make a right situation? The interesting thing about this is that the Commonwealth never even thought about having an expert to come on to say this wasn't a dog, because their experts are saying that it was from an automobile accident. So like, they don't, like, his thing is like, well, we didn't have Kuhn testify, the woman who did the DNA swabs, which are useless to me. Let's be real. If they wanted to send the best evidence to the lab, they would have sent John O'Keefe's two-tone sweatshirt, hooded sweatshirt. That's what they would have sent. Instead, they cherry pick. We have no idea where they pulled the swabs from on that thing at all. Like, why wouldn't they send the entire hooded sweatshirt to the lab and let them do their work? Right. You know what I'm saying? Like, that's the best evidence of the case. That is, without question, the best evidence in terms of trying to determine whether or not there's canine DNA on that shirt anywhere. Not two cherry pick swabs where we have no idea where they swabbed. Did they swab in that thing that looked like a puncture hole? If I'm Lally and there's any thought in my mind that this dog thing might have legs, I'm directing them not to swab there. Yeah, swab not really right near that puncture hole thing. Like, go on down the sleeve. I mean, you send the shirt to the lab. That's what you do. But I think ultimately, you're going to have to balance Karen Reed's Sixth Amendment right. right, against their ability to be able to look. We've had late disclosures at trial, like day of walking into a courtroom, and the judge is like, "Okay, I'm going to give you 15 minutes. Go talk to the cop out in the hallway," type shit.
Right.
So it's like I realize that the eyes of the world are on this case right now, but it's still court, and there's got to be a workaround where I just think that when Canoni, and I know that everybody thinks she's biased, I think that more recently she's been pretty even-handed. But I'm accustomed to having judges sustain objections that the state makes all the time. I mean, it doesn't make it right, but it's factual. It happens. Defense attorneys, it becomes just kind of like a Pavlov's dog thing. You're trained to it. It's like it happens in I've never had a trial where we've won a majority of the objections. You know what I'm saying? So I think ultimately that Canoni will figure out. She's not going to be happy. She'll admonish the defense. She'll probably make threats. She'll make them sweat, but I think that she'll make some kind of workaround. Before I could tell you're ready to jump into the testimony, but I mean, do you think that this rises to the level where like a Daubert hearing is going to have to be had?
No, I don't think so.
No way.
It just doesn't. It doesn't seem like it's that. There's nothing new.
Right. It's not new science.
Right. Right. So, and the rule says, the case they cited says, a court should only employ this sanction, being exclusion of the witness, when convinced that a failure to comply with an order was deliberate and prejudicial to the Commonwealth. So deliberate is going to depend on like how long it took them to get, to find this expert and decide to use this expert, So, and I don't think a Daubert hearing is necessary. Like we're saying, I think that there's a workaround that can be had.
Yeah, and look, I mean, this thing's not rocket science, and I think that she can allow for like a voir dire of Russell, and that's basically, we've seen a couple of them in this case, and that's essentially where the jury's out of the room. Lally's got their expert up on the stand, and he gets to question her, and at that point, the judge is going to determine whether or not she's an expert. I mean, he's obviously going to point out the fact that she seems to be an ER doctor. It's certainly not her, like dog bite wounds are not her expertise.
Right. So, that to me, she's an ER doctor who's treated several, but there's definitely like, I'd assume a dog bite expert,
Yeah. People who deal exclusively with dog bites, especially
and a forensic person.
Yeah. Or like plastic surgeons that have to rebuild people's arms and appendages when they've been attacked by dogs, who would be pretty familiar with it. So, I mean, we'll see how that goes. I'm not sweating Lally for filing it. I mean, anybody would. Doesn't matter what the case is. It's a late disclosure. So it'll be interesting to see how Canoni goes. I hope she rules the right way. I mean, it should come in, but it's got that third party culprit angle to it, like this, when she rules on this motion, it's going to be a little peek behind the curtain into her brain and where she's at with the third party culprit stuff. And what we're about to get to today may have moved the needle a little bit, but I want to first go through the direct.
Well, no. So we're actually starting with some of yesterday because we said we wanted to.
Well, that's the direct.
Right. So, yeah. Direct. Sorry. Yes. But direct from yesterday, we're going to try to breeze through this. So first we're going to start with Reed's statement to this trooper.
When you proceed inside the home and when you get inside the home, where did you go and who, if anyone, did you speak?
We were directed by Mr. Reed to the living room where the defendant was seated on the couch. She had her laptop on her lap and her phone resting on the right armrest of the couch.
Now, in addition to the defendant and her father, who, if anyone else, was present when you talked to Ms. Reed?
The defendant's mother, Mrs. Reed, was also present in the home.
And the defendant's mother and the defendant's father, were they present throughout the course of your interview or your discussion with Ms. Reed?
Pause it 1
Yes, they
second.
And at any point in time, did you ask them to leave or anything?
All right, so we're doing this for y'all. Now my wife, she can listen to shit on like 2.5. Like I don't even know how she can hear it. Like she'll have the robot read cases to her, and it's like indecipherable to me. Since we're doing this for y'all, she's trying to make this so it's not overly painfully long for you guys. Let us know in the comments if it's too fast. I don't like
I
the
can
setup
crank it down
stuff.
to 1.25 and you won't be able to.
Well,
know.
I'm just telling you, when we get to Jackson, who's a fast talking guy, I don't want it sped up at all. I want it regular speed. Lally speaks slowly, so it might not. But let us know. I'm gonna go by what y'all say. If you want it sped up, or if you're cool with it sped up, we'll keep it sped up to kind of make this go a little quicker. If not, then we'll put it to regular speed.
And again, I can go one lower than where I'm at.
Anything like that?
What are you
I
at?
do not know.
Don't
Now,
worry.
with respect to, can you describe sort of the demeanor or the tone of the conversation that you had with Ms. Reed that afternoon?
It was polite, courteous. She had just went through a traumatic event, so we were considerate of her losing her boyfriend. And we had a normal tone conversation. We were in the information gathering, fact-finding portion of the investigation. We simply wanted to collect her recollection of events that she remembered.
And so throughout the course of this interview, how are you standing, are you seated, or how are you positioned in relation to Ms. Reed, and how is she positioned in relation to you?
She was sitting on the couch. We were standing across the room. I don't recall if there was a coffee table, but if there was a coffee table, we would be standing on the
Regular
opposite side of that
speed.
coffee table, if there was one present. I do not
No
remember
way.
if there was one present.
They
But that's the
sound
distance,
it's subhuman.
approximately
They sound like fucking robots.
from me to the
man.
defense table.
All right.
And
Just so we know, he's asking these questions, and I know we always want to be like he's lollygagging. I forget who said that today.
Why do they pronounce that guy's name Lally? It's spelled Lally. That's Lally in any part of. Is that how
It's
they?
the accent, I think.
Lolly. I don't know. Maybe.
So in any event, it's to be as the judge always gives those instructions that the jury has to find that the statement was actually made by the declarant and that it was voluntarily made. So this is going to, that she was in her home. It was a relaxed environment. There was no pressure by the police to make. So that's why these questions are being asked.
if you
And
could
I want
describe
to
the
hear
jury sort
this
of how
testimony, so I'm glad we're putting it to regular speed. It's too much at fast speed. Like people that are acclimated to it, I guess it's fine, but for us that like hearing people's normal voices, it's way easier to understand what they're saying. And this is important testimony.
Okay, ready?
Yep.
how did that interview or how did that conversation begin? What was said?
First things first, we introduce ourselves, advise the individual we're speaking with, who we are, where we work, and what we're looking to find out. The defendant was advised that we're looking to get a recollection of the events, what happened, what she observed, what she remembers from the night before, and to walk us through the last 24 hours or so of activity.
And prior
Do I need to give an instructions to Larry? I'm not sure exactly. Why don't I see counsel at sidebar for a minute?
All right, so she's going to give the instruction. Lally's like, I don't know.
Hear testimony, voluntary, and where the statement was made, the nature and reality of the surrounding circumstances. I'll instruct you about this again. All right, with that, Mr. Lally?
Thank you, Your Honor. Now, Sergeant Buchanan, when you began to speak to the defendant, prior to any sort of substantive conversation, what, if any, conversation did you have with her about the conversation you were going to have?
I just asked her to recount any events and the history between the actions that were taking place.
And how did she initially respond to that?
She stated that she's willing to answer our questions. She just doesn't want to go into too much detail about what transpired. And given the circumstances that she had just lived through, I understood and gave her that courtesy.
And as far as that interview or that conversation went, can you describe that conversation or the contents of that conversation to the jury?
Absolutely. The conversation was normal tone of voice, like I am speaking to you right now. Ms. Reed responded in the same tone of voice, answered questions. The content of the conversation began with her saying that As I stated, she doesn't want to go into too much detail, but she was willing to answer our questions. We asked what she had for plans, what she had for as far as activity the night before, leading up to Mr. O'Keefe being discovered. She stated that she was in a relationship with Mr. O'Keefe that morning, meaning the 28th of January. She got into a fight with Mr. O'Keefe over what the niece and nephew were being fed for breakfast, or what they had for breakfast. She went on to say that she met Mr. O'Keefe at C.F. McCarthy's approximately 9 p.m. the night of the 28th of January, 2022. She stated that the gentlemen were drinking, consuming beers, Bud Lights, and she was drinking vodka soda. Prior to moving on to the bar at Waterfall, the defendant was asked where she parked her vehicle. She told me that she parked her vehicle on Washington Street across the street from C.F. McCarthy's, facing northbound. So the vehicle was on the side of Waterfall Bar and Grill. We went on through the conversation in the interview to the Waterfall restaurant, at which point she was asked if she left C.F. McCarthy's with a beverage or a container from that establishment, to which point she stated that she did not.
So he's going to circle back, he being Lala, he's going to circle back to this point and show video that she did take a cup out. So I think they just wanted to get this in because they think it shows consciousness of guilt that she didn't want to fess up. But I don't think the allegation is that glass is the same glass. So I guess they just want to show she's a liar. If they had thought it was the same glass, maybe it would speak to consciousness of guilt, but they
No
don't.
way. So I don't think that's ever been like, cause she's drinking out of like a highball. Like she's
Right.
got
And then this
tall,
is
she's got the tall vase-like glass that I see.
right. So it's just to show she lied, or at least that's what he thinks, even though I think the jury's thinking she just doesn't remember. Everybody was drinking and drunk, and it wasn't something memorable.
Right.
She also confirmed that Mr. O'Keefe did not have any injuries on him when she interacted with him at C.F. McCarthy's or the Waterfall. She did not get into any verbal or physical altercations with anyone to have sustained those injuries. She stated that once at the Waterfall, they stayed for approximately an hour, hanging out with acquaintances. And then they left the Waterfall. She drove them after they were invited to a residence, she drove them to a location in Canton, where she dropped Mr. O'Keefe off. She was asked if she saw Mr. O'Keefe walk into the home at 34 Fairview, and she stated she did not. She stated that she made a 3-point turn after dropping him off and left. She was asked whether or not Mr. O'Keefe, excuse me, let me back up. She was asked if she knew how she found out about the damage to her vehicle, to which she stated, quote, "I don't know, it happened last night," end quote.
Wow. Now, at some point earlier in the interview, what, if any, indication did she give as to who Mr. O'Keefe was with when she arrived at C.F. McCarthy's, and sort of how long he had been with those respective people?
Pause it for 1 second.
She indicated that.
So he stops himself there. He was about to get into whether or not she saw John going into the house. And then he stops himself there and he says, "Let me back up." He's a mess right here. Like, this is the only portion of his direct where he's a mess. If we were to have Jack with never a truer word on here, he'd be picking this apart right here. But in terms of the 3-point turn thing,
I wonder, did they ask her, well, based on how you were facing, what would you have done to pull away? Or is different than she's just like, oh, and I did a 3-point turn,
Yeah. Yeah, and he really is focusing on the fact that, like, he made it a point to talk about in stark contrast to every other witness that the state or the Commonwealth has put on, that she was frantic. So this is the only witness that they put on thus far that has Karen in a calm state. right? So,
And knowing
but,
that she dropped him off and knowing what time she did and remembering all those details.
but oddly enough, in this calm state, she's not saying I hit him. She's saying I don't know what happened.
Right.
Right.
Mhm.
Mr. O'Keefe was with Mr. Camarano, Kurt Roberts, at which point she was asked to provide contact information, meaning phone numbers for those individuals, at which time she picked up the phone on the right armrest of the couch, manipulated the device, entering a passcode, and provided that phone number to Trooper Proctor and I.
Strange.
At any point in time in the conversation or interview you had with her, what, if anything, did the defendant say in regards to why she had not gone into the residence at Fairview Road herself?
The defendant stated that she was having stomach issues and did not want to enter the residence.
Now, what, if anything, did she tell you about the later on that morning of the 29th?
She stated that when she woke up, she began looking for Mr. O'Keefe. And when she found him in the snow, she began CPR on Mr. O'Keefe.
And what, if anything, did she say to you about any observations she made of Mr. O'Keefe later on that morning as far as any injuries to Mr. O'Keefe?
The defendant stated that while she was performing CPR, Mr. O'Keefe had sustained injuries and was bleeding from the nose and the mouth.
And if you were
So I found it strange that it seemed like he's implying that she said that he sustained them while she was doing it, as opposed to she noticed that he had those injuries while she was doing it. Am I misreading that, do you think? What the hell? I can't hear you.
It's me.
I can't.
I was muted. No, I don't think you're misreading it. But does he circle back and say that she claims that John O'Keefe never went into the house? Does he ever circle back and say that?
It was just that she didn't see him go into the house. She didn't watch him, is the way I took it, that she didn't watch to see him go into the house.
Okay.
recall, what, if anything, did she say about Mr. O'Keefe's eyes at that time?
The defendant stated that Mr. O'Keefe's eyes were swollen.
Is that both eyes? Is that correct?
That's correct.
Now, as the interview progressed, at some point, did you ask questions seeking further details?
Yes, I did.
And details about what specifically were you asking?
Once we got to the point in time where the defendant told me she did a 3-point turn, I asked her to walk through step by step of her operating the vehicle and exactly what she did. Prior to that, I asked her, so she was asked to give a step-by-step recollection of how she, what she did in manipulating the vehicle and leaving the scene.
And at that point, was the interview terminated?
Yes, it was.
Now, once the interview concluded,
Okay, so I don't know. What do you make of all that? To me, it didn't seem like a hell of a lot. I don't really get.
I didn't think it made any points for the Commonwealth. You know, like I didn't find any of this line of questioning to be particularly damning to Karen Reed, to be honest with you.
Me neither.
Like I didn't walk away from this portion like, oh shit, she said all kinds of shit. You know what I mean? It's like I just felt like she said some things. Now it can obviously be argued that she's being careful. You know, she's had time to go. If you're of the mindset that she's hit him and is aware that she hit him, then, you know, she's had time to prepare herself, which hence the calm demeanor, and she's not upset. You know,
Right.
she's had time to talk it out, maybe with her father. You know, that's the counter argument to it. You know, but I think her saying that she doesn't remember could be the truth. You know, depending on whether or not. Now, is this before or after we spend an hour going through what she had to drink at the bar? I hope this is after.
This is before.
Oy. So we're speeding through that. That
Yeah,
was
we're not, I'm just gonna say what he said. I don't think any
Right.
of that's important.
we don't need to watch that. That was brutal. Like I don't even know why he did that. It's like talking about putting a jury to sleep. It's like, oh my God. It was painful to sit there and go through it when all he had to really do was show small clips 4 different times of her getting handed a drink and then produce the receipt and say, okay, here you go. You know, and $52 at $10 a pop for Tito's. And we
All
know
right,
one
well,
of the drinks. What? Oh yeah. Sorry.
Yeah.
I was getting ahead of myself.
And check my text. All right, so this is one of the videos that he puts in.
It is.
As far as the vehicle is concerned, what do you recognize that vehicle to be?
That would be the Lexus SUV owned by the defendant, Bear, Massachusetts registration 3 GC 684.
Someone speak at the press plate, right? This one, if you could pause right. 2 individuals just exited that vehicle, is that correct, Sergeant?
That's correct.
Do you recognize who those individuals are, as far as who they are, from what part of the vehicle they exited from?
Yes, the passenger side exit was the defendant, and then the driver's side vehicle was Mr. Reed.
That'd be the defendant's father, is that correct?
That's correct.
Just going to be the place. Yeah. Now, Sergeant, towards the end of that video, did you observe the defendant and her father in any specific area in relation to that vehicle?
Yes, I observed the defendant and her father at the rear right taillight, gesturing or signaling towards the affected, damaged, and missing parts of the taillight.
Objection.
I'll allow just the direction that they were signaling out.
Move to stretch later.
Okay?
So, I mean, that was dirty pool by the state trying to get in that they were gesturing at the taillight. Like, I don't even know how he would even know that that's what they were doing at all, as opposed to just talking about the car. But whatever, the judge struck it, the jury heard it. I don't know, you know, so it's just, it kind of is what it is, I guess. And then they play a second video. Here we go.
In this particular video.
This video captures the vehicle being moved into position to be loaded up onto the flatbed for transport from the scene.
Gentlemen, if you could play for them. Pause right now.
I'm sorry.
I just asked her to pause right now.
Yeah, you really have to keep your voice up.
Sergeant Buchanan, from this still image from this video, what, if anything, is significant you observed in relation to the vehicle at this time that is being loaded onto the tow?
The rear taillight is illuminated. You could see a white light coming from that taillight.
If you could, using that laser pointing out before you just direct the jury's attention to the specific area you're talking about.
Right there.
Just go ahead and you can play this through the Let's go when you can take that down. Now, Sergeant Mechanic, as far as when you left the residence in Dayton, where is it that you went?
Can we turn the lights on, Mr. Lally?
Yes, on my fault.
All right, so now he just starts talking
Once we-
about how they went to the,
And in reference to,
let me just, that they went to the Sally Port and they unloaded the car at the Sally Port. Now they, and they go to put in the video from the Sally Port. And I'm going to put us at where he first goes to put it in, because what's happening in the courtroom is pretty interesting.
Yes, I do.
and what do you recognize that to be?
The Canton Police Department driveway with video.
And what's contained on that is that fair neck of a trailer of yourself and the tow truck pulling into the Canton Police Department driveway on that afternoon or early evening of January 29th.
Yes, it is.
May I approach, Ron?
Yes.
Almost, you can introduce the minutes of that exhibit.
Okay.
Now the defense says I need to speak to counsel. And they're having this pretty serious powwow. And what we can assume this powwow includes is, well, he just said that it's a fair and accurate portrayal, and we're not going to object. Maybe we need to object. He's like, well, I think it was a fair and accurate portrayal of pulling into the Sally Port, because this first video, you know, is going to be that. And whatever they decide to
Okay.
let it go, no objection.
Yeah, and obviously on
Your Honor,
cross,
with the court's permission,
this becomes critical.
So they first put in a part, and it shows that the tow truck is arriving at 5:31. That's when it's pulling up, and then he's followed by the car that the trooper is in at 5:31:27. Then they talk about how it's in the interior of a Sally Port. It's heated. Once the doors shut, the snow melted. And we are going to start this.
And I just want to make we usually give this disclaimer in the beginning. You know, we realize, Allie and I both realize that this is a highly contested case. We've got people dug in on both sides. Allison and I are fence riders. You know, we wait to see the evidence, which is frankly, what everybody should do. Anybody having a final opinion on anything at this juncture is wrong. You can't possibly know until you see all the evidence. But notwithstanding that, I'm not going to judge it. But we don't want an echo chamber ever in our chat. We never allow for it. But our rule is just be cool. You know, debate it all you want, but be cool. If you name call, if you start insulting people, you get booted. So just be cool. We love debate. I mean, Allie and I argue for a living, like quite literally. We're paid to argue. So I never take offense when people take an opposite position as I have. And I live for it, actually. It's the spice of life. So, you know, just keep that in mind in the chat. I like to see spirited debate. I think it's healthy. I think that if you allow your mind to hear other people's opinions on things, you'd be surprised. So you guys go at it in chat, but just be cool. All right.
So I think it's fair to assume by now that everybody knows, and if you don't, you're learning now, that this video is inverted. It has been inverted. It is a mirror image. And you can see here the word police is backwards, you know, and this witness will testify on cross that it is inverted. But this is direct. No one has mentioned to anyone that this thing's inverted. So this is the question that now, first of all, I do want to note there is snow on the ground. Bob, you pointed this out, in the shape of a vehicle already. So that tells us that during the snow, a vehicle has already been pulled in there.
That had snow on it.
That had snow on it, correct. And you can see this bay door over here has been open long enough for a lot of snow to gather there, and a car was driven over it. What that means or what it doesn't mean, you know, who's to say right now? But these are things that are noteworthy. A car coming in from out, there's not going to be any snow there when the car first pulls in, right? There's not going to be snow inside unless they just left the bay doors open, which seems, you know, unlikely.
Insane.
Right. So as it's pulling out and the snow has accumulated this much for as long as whatever car was there was sitting there. And look, it could have been that somebody pulled their car in that works there because it was snowing and they wanted to put it in, and then they realized they had to pull it out because a car was coming. You know, so I'm not making any, I'm just pointing this out. But snow gathered enough for when this car left out this way, it made marks in the snow that has accumulated. So this is a question. This is the question that Lolly asks of the trooper about how actual position of the car and which side of the car we're looking at. And knowing what we know now, you'll have to say, was this complete bullshit or what?
and first of all, do you recognize what's depicted in the studio?
Yes, I do.
What do you recognize it to be?
That is the Sallyport two-bay garage at Canton Police Department with the antique Canton Cruiser on the bottom of the screen, and the open spot for a vehicle in the middle of the screen with the four-wheel drive all-terrain vehicle at the top.
Now, as far as, again, for orientation purposes, the driveway that the jury just witnessed in the prior exhibit, is that to the left of the screen, the right of the screen, or something else?
The driveway is to the right of the screen.
But it's to the left in the
Right.
of the actual bay. So here we go.
And this vehicle, the defendant's vehicle is sort of taken into the garage on the opposite side, or to the left of the screen, is that correct?
Correct.
Ms. Yeoman, if you could, wait. May we approach, please?
Okay, could you pause that, Ms. Gilman?
So now, you know, I'm assuming that part of this had to do with the accuracy of that, but you know, but we don't know.
I mean, to me, the question is does Lally tell him or Lolly tell him ahead of time that this video that they're using is inverted, that it's a mirror?
And that's why it seems to me that him going up at this point in time has to deal with that, because the question, he literally objected when he spoke about the orientation of the car and of the bay and, you know, of the garage. So to me, you know, that's what it seems like. So now we're gonna skip ahead. Oh wait, this is where I wanted to get. What did I-
Her lip reading.
Yeah, I'm supposed to be at 50. I'm sorry, I'm at the wrong spot.
See, now we have
video.
context. Now we know that she's saying they got it wrong. What they're saying is left is right.
Yes, I
That's
do.
what she says when you see her lip reading.
Right. So here we go.
Recognize it to be?
Oh, we
That
just
is the
did that.
Sally
I'm
Bottom of
sorry.
Now,
Jeez.
as far as
5244 sidebar. Okay. 54.
Short afternoon break on our long days at about a half an hour, but I think the better use of our time is to give you a 10-minute break now. And then we'll go straight through till 4 o'clock. If anybody needs a break.
all rise for the court, please.
So they take this break immediately after they raise this issue. And then the judge says that they're gonna, and here's Karen. It's on the wrong side. The left is the right. She knows everyone's watching. All right, so then they make the witness leave. Okay, and
Leave
what
the stand just for a moment.
judge wants us to watch this now.
Yeah, we'll see you back here in about 10 minutes, Sergeant.
You are unmuted.
Okay, so you want us to watch this now?
If you please report, yes.
And that's all that's said, and they watch it. We're not going to watch it right now because it's going to come in. I'm going to take us to immediately after they watch it. The only other words that are, you know, spoken. Here we go.
All right, lights on, please, Dave. Thank you. All right, so I have a copy of the printed docket on 424. Paper number 347 was the Commonwealth's Notice of Discovery XL. I just asked Mr. McDermott.
Okay, so I'm highlighting this because she talks about that this was discovery on 424. So part of the issue is clear that what they were looking to determine was this version of the video and what day was this version of this video provided. So it was on 4/24/24, unless it's 23. Yeah, the day that they had their big motions in Lemonade. So
24, yeah.
right. And that's all that is said. and then they go to their break. And now we're going to go to when the jury's back in the room and they're actually playing the video. Okay. Oh,
Yes, it is.
Just gonna let you go right from there.
and this is when the world, attentive parts of the world, see that the driver just came out of the passenger door.
Sergeant, I was following the video.
All right, so keep your voice up.
Sergeant Buchanan, with reference to any individuals you see in this video, do you recognize any of those individuals?
I can recognize Trooper Proctor and myself. Other than that, I don't remember exactly who else was present.
Okay, so he's asked this precise question on cross-examination, and we will see it. And he says that he's not sure who those people are, and that he didn't say that that's him and Proctor. So clearly, that's exactly what he did just say. Now, I don't know that the jury's going to remember that. It's a lot of people, a lot of things. Like, they may not remember that specific, interaction.
Well, that's where you rely on closing arguments. That is like obviously a major point that you're going to bring up at closing, because when we get to the cross, when he won't admit that the guy towards the rear of the vehicle on that screen right there is Proctor, and Proctor walks behind the vehicle, which we now know is inverted and appears to be standing right behind the broken taillight.
Right.
Side area of that.
No, we did not.
And let's go in if you can play from here.
Oh, wait. Sorry.
At any point in time when you were present with this vehicle in the Southport garage this evening of January 29, 2022, did either yourself or did you observe Proctor touch or manipulate in any way the right rear passenger side area of that?
No, we did not.
So the right rear passenger side, although what we're looking at is what appears to be the right, but it is the driver's side. So again, no one's fixing it. No one's saying anything. And we don't know, as we sit here right now, whether they knew that the defense knew that this was inverted, and that he's saying it's the right side, but that's actually the passenger side.
Right.
I mean, the driver's side. Sorry.
Unless we're in England.
Right. Okay, so now we're going to jump ahead because it's just them watching. Nothing really happens. He doesn't ask any questions. Now, this is something I think that I want everyone to look at.
Someone keep your pause there just a moment. Sergeant Mechanic, from what you're observing in this video, what you've seen or what you recall from this, what is it that you and Proctor and some of the other officers are doing now?
We're establishing a perimeter around the vehicle with yellow tape in order to prevent or alert and advise anyone in the area to stay away from the vehicle.
Now, I want you guys to note this draping. So it's going around what we now know is the driver's side. It's not coming over here near this other, oh, damn it, sorry, near this police car. And it's sort of draped over here. And then so they've put some other photographs into evidence during earlier times of the proceedings. Now, for instance, I'm gonna pull up one and show you guys right now. Okay. I'm gonna have have to share my screen differently. Sorry, babe.
It's okay. Are you trying to send yourself the picture?
I got it.
Okay. Now you got it.
Yeah, I want to hope I can share just this part of the screen. That's what I'm not sure of. So. Hmm. Hmm.
Thanks, Fire. I'm not sleeping.
Oh, Lord.
It always starts. It always starts. If you get a higher chair, maybe.
Hmm.
I mean, do we really need to see this picture?
Damn it. Let me see if I can.
I know that you were kind of obsessing over this
Oh,
picture.
can you guys see this or no?
No, they're super teeny. Can you blow them
Oh,
up?
you can't see this thing that's over here. Like this thing. No.
What thing? No.
All right. All
You can
right.
see exactly what's on the screen.
Seeing all my texts.
Oh. Wow, wow, wee wah.
Um,
What you got going on?
let's see if I can try one more time.
JS says, yes, show pictures. See, you put a teaser out there now.
I know. I got it. I think I got it. Oh, I did it.
Yay.
Right.
All right.
Is it big?
It's huge.
Okay.
Huge.
So this is now actually, and it's obviously a different time. So I'm not saying like they're trying to make it seem like it's just this time. But in my mind, the way they took this photo, where now this is the passenger side, right? And it's draped. Oh, I mean, this is the driver's side, and it's draped over the passenger side. You know, the other car is over here, and you see this tape. It's reminiscent of the other screen. So in my mind, I'm like, are they trying to just kind of make it seem like it's the same? Because it's very reminiscent of, we'll switch back now.
Because that, and in this picture is in evidence.
This picture's in evidence. Correct.
Which means that the jury can ask to see it during deliberations.
Right. Right. And you know, if you're not really, you know, like if they hadn't known all of all of this about the inverting, you know, like now here's a picture where you can clearly see the driver's side's over there and that this is the passenger side, and it makes someone think, well, that whole time when we were looking at this before, it was always the passenger side that was to the right. That was the side that had the thing draped over it. So we'll switch back now. I hope I hope it made sense, because it didn't make sense to you at first, like when I was what happened?
I don't know.
Okay. Can you see that?
Yes. Wait,
All right.
you don't have the screen up. That's why you keep asking, right? You don't have the
Right.
screen.
Because I don't have dual screens like you.
But
So
you do. You actually have 3 massive monitors right there, including one right in front of you that are huge Thunderbolt displays. You just choose not to use them.
Yeah, it feels like it's Darren's area when it's like that.
I use those things down there all the time. They're magnificent.
I know. So all I'm saying is, you know, it's a completely different scene in that other photograph, but the way they have the you know, the tape draping, it just seems to be drawing attention to the fact that picture that was always the passenger side it was taped on. Inverting does not change the fact that this caution tape is literally touching the driver's side, and there's no tape connecting over here to the the police cruiser as it was in that other video. So I don't know. I don't know what it all means, and I don't know if I'm making more out of it than I need to, but you know.
Well, I mean, the real question is what is the jury making of it? You know, is there so much coming in that their recollection as to things that may seem mundane at the time, like no one's taking vigorous notes when they put that picture up on the screen initially, you know what I mean? Like that's just not one of the things that you're going to see jurors like notating in their notes. Oh, like they might note the time that the SUV is moved into the Sally Port, but they're not going to say, okay, the SUV is there with the crime scene tape around it. You know what I mean? So it's like the question is, you know, but that's one of the things that the defense is very good at in this case. You know, they're highlighting this. They're going to refresh the recollection of the jury. I wouldn't be surprised if the defense brings that picture up, you know, in order to
Say that they were trying to fool you.
right. That, you know, this is what they put into evidence initially, or at least in closing, you know, but I do it with, you know, BUKHENIK up there. BUKHENIK? What do you think? BUKHENIK? Yeah, BUKHENIK sounds right.
Yeah.
I'll have to go. I'll do like during the cross, make sure you stop where he tells Jackson how to say
You're
his.
going to be controlling the cross, so you might as well boot it up.
Oh. Well, thanks
Okay,
for-
so then we get to the fact that they talk about how after February 2nd that the vehicle was moved to another garage because they needed to have that. I'm not exactly sure why they focused on that, but then they turn back to February 2nd and they talk about the video at 8:09. So this is
Warrant was
from
executed on that vehicle on February 1st of 2000. Next is on February.
From the Canton Police Station, I escorted the vehicle to the Milton Barracks.
okay.
Canton Sally Port.
Right. So this video is February 2nd,
About 8:09
8:09 a.m. It's from the other angle, but it's not the same day. It's the day of the search. So now it's the video showing it.
Sergeant, just for orientation purposes, again, this is another camera from within the same Sally Port garage, is that correct?
That's correct. That's the opposite view from what we just viewed in the previous video.
And as far as any of the people in this video, do you recognize any of the individuals in there?
I believe that's myself and then another officer. I don't know who that other officer is.
And just again, using the laser pointer, if you could direct your attention to where you see yourself.
I don't know how anybody sees anything. I can't see a
As
thing.
far as the condition of the vehicle.
Right.
from
I've
February
seen
29th,
people
on
brighten
that
it
day,
up.
February 2nd, when you saw it on that day.
Brandy
Was the
Churchwell
exterior
brightened it up
what
a
if
bit.
anything was different, or what if anything you know?
So my question is this really the other angle, or is it just the you know, oh, it is definitely the other angle because he's so close to the wall here. But why from this angle when you can see the passenger side is everything so dark, but from before everything it was a brightly lit room? And I don't know, maybe they'll get into that on cross. So that's the video, and now he jumps into
The drinking.
no, they discuss the video from John O'Keefe's ring camera area. All right. Then they go to a sidebar. So he starts to try to say something about, you know, what the deal is with the ring camera. And then when they come back from the sidebar, he does not mention the ring camera again. And then we get to this. I have this time stamped without a note, so hopefully it's where I want to be. 32. Okay.
Officer, who was the case officer on this particular investigation?
The case officer in this investigation was Trooper Michael Proctor.
And Trooper Proctor works under your supervision, is that correct?
That's correct.
So as far as a search warrant for the ring video from One Meadows Avenue, who specifically sat down, put pen to paper, and wrote the search?
Trooper Proctor was the affiant.
And as far as
Can you
that
bump
search
the
warrant,
volume
where
on the video a
materials
little
are
bit?
provided by Ring in response to that search warrant?
I'm going to allow it.
I am aware of it.
And have you reviewed both
Still
material as
low
well as the videos that were
me.
provided by Ring in response to that search?
I did.
Now, with reference to those videos, specifically, did you observe a
All right, Stanley just kind of stumbles over himself.
scope of the request?
Lally stumbles over himself? No.
Right. So they were going out of their way to say how he knows about the Ring camera, he knows about the warrant for the Ring camera, and he knows they sent the warrant out, and Michael Proctor was the affiant and all of that. So now we get to the Ring camera videos.
Ms. Gilman, if I could have from what's been previously marked as Exhibit 6, first video.
One thing I want to say about Lally, because I'd be saying it if it was the defense attorney, is that he appears to be trying this case solo, which is insane to me. I don't know who put him in a position where he's got no support staff helping him go through this shit. But to be honest with you, I think that that's a very, very tough task. Anybody who's tried a case will know that's a reality. Like people like to give him a lot of shit, but the reality is that this guy's trying to pour through massive amounts of evidence. You saw it. You can hear him. You get hot mic moments with him all the time where he's like, son of a bitch, trying to go through a million photographs. And then he's got this teeny little table right in front of the bench. So I know people are tough on Lally. I mean, he's got a Herculean task here in terms of getting everything into evidence, preparing all the cross. Like he's got no buffer. Like he's got to direct every single witness. He's going to have to cross every witness. It's a lot. It really is.
All right.
If you could pause there, Ms. Gilman. Now, with reference to this particular video, number 119 in Exhibit 6, Sergeant, what, if anything, can you tell the jury as far as the timing of this particular video?
Based on the appearance of the driveway, we know that this recording took place prior to the blizzard of January 29th.
So he testified earlier that they sent out the request with a parameter of dates, but that when they got everything back, there were no dates and times. So that's why he's saying, all I know is that based on the parameters, that this is sometime before the storm happened, close in time to this. But I just find it strange that he's using this video and that the judge let it get in. She's not parked in the garage as she was in the pulling out that matters, where she came into contact with the car. So why this is supposed to prove, how she maneuvers, and he's trying to make it show like she knows how to get around this car, but she's not even pulling out from the same location. But here we go.
As far as anything that you observe in this video, as far as vehicles or people within those vehicles, what, if anything, did you observe within this video?
I observed Mr. O'Keefe's car parked in the same location as he typically parked it, and then
Objection.
I'll strike the as he typically does.
Right. So again, them trying to just sneak stuff in that they both know. This guy is a career, officer. He's testified who knows how many times. So the judge strikes it because who's he to say, Mr. Expert of everything? Now he's the expert of where John O'Keefe typically parks his vehicle. But
Well, I mean, this was the same thing that was going on. And from an attorney's perspective, Alice and I were losing our mind when they kept, when they were going through the Alberts and McCabe's and their testimony, and they were consistently showing that kind of a long shot of the house from a distance. And it clearly was after the snowstorm, which is not accurate in terms of reflecting what the property looked like at the time of the incident at all. And you and I are like, why are they objecting to it? Because it's not a fair and accurate depiction of what the property looked like at the time of the accident. Same thing stands like for this, but I mean, you have to assume that these are issues that were dealt with pre-trial in terms of what evidence was going to come in, what wasn't, which photographs were going to be used, because they allowed the defense to use a computer generated photograph, like an AI type, like that thing that the defense always used. They tried to be accurate as to the amount of snowfall, you know what I'm saying? But it wasn't like an actual picture of the house. So
Right. And
there was
babe,
probably a little give and take there.
I take it back. I'm going to want you to start when we get to today, because I do see people complaining about the volume, and you have like that booster thing you can
But
do.
why is it so low? Like we played it like it sounded completely normal all day. Like the day we played it.
I don't know. It might be that you guys have boosters. I don't. But where we're going to start is 29:10. Okay. So, but I got to finish. We don't have much left on this day. So I'll keep going from here.
Okay.
Where was I? 20.
LV says volume's
And
good.
then,
For me, it's a little low.
A black SUV parked perpendicularly to Mr. O'Keefe's vehicle, adjacent to the entryway to the garage.
It's going to be the correct way to go. It's going to be the closet. At some point in the course of your viewing of this video and the video surrounding it, you'll be able to identify the operator of the vehicle, black SUV.
Yes, that is the defendant operating her black and color Lexus SUV bearing Massachusetts plate 3 GC 684.
And if this gentleman, if you could play.
I mean, they then proceed to spend huge amounts of time insinuating that she had 9 cocktails and was back in. You know what I mean? You can't have it both ways.
This is before. So
I
there's
understand, but what I'm saying is they're comparing a situation wherein they spend an inordinate amount of time trying to prove that she's hammered,
5 a.m. on January 29th.
and they're comparing it to some period of time when we don't know when it is, when she clearly hasn't been drinking. You can't
Right.
have it both ways. Like they're not at all similar circumstances in any way, shape, or form.
not to weather, not to literally her direction of travel, because she's coming at it from a different angle, as we're about to see when they show the actual video. All of the things you're saying. Absolutely.
And she's sober,
Right.
and there's no snow. I mean, it's not dispositive of anything. I don't know how that video made it in.
Right. Me neither. And I don't,
View of the ring videos from One Meadows Ave. Another video depicting the defendant leaving the house sometime shortly after 5 a.m. on January 29th.
Yes, I am.
so now they know the time.
Gilman, if I could also from Exhibit 6 ask for, video 153.
Now they know the day and the time.
If you can just pause there for a moment.
Right.
Now, Sergeant, with reference to this video and the one just previously from 119, where is Mr. O'Keefe's vehicle parked in relation to this video vis-a-vis the other video?
The vehicle's parked in the back corner of the driveway along the fence in the same location as it's parked in the previous video.
And at some point, do you see the defendant's vehicle back out of the garage in the same directionality that it did in the prior video 119?
Yes, you do.
Bullshit.
Ms. Gilman, if you could address.
Same directionality, completely different angle. She's coming from way further over.
Right. Out of the garage.
Right.
You can see coming straight back. Even if she didn't move, she would have been up on the vehicle.
Pause there for a second. Now, as far
Like,
as
if she would have made no
Talk
turn in, if she hadn't cut her wheel, she would have backed straight up. She would have been inches from the vehicle on a straight back up.
Right. All right.
Are you able to observe who that operator is within that vehicle?
I observed the vehicle being operated. I cannot identify who the individual is, and then from that shot right there.
From at any point in the shot of the video that you observed, are we able to recognize the operator?
Not from that shot, no.
Now, with respect to the timing of this video, what time in the morning is this video?
The timing of this video is approximately 5:07 a.m. when the defendant left the home through the garage via her vehicle.
And this gentleman, if you could play through that.
I spent so much time looking at that exact frame right there. Hours looking at that exact frame right there.
Bob and I think this was maybe the cleaned up video that was late discovery by the
Yeah,
state.
you guys remember when we got the medical report for Higgins, the enhanced video? It seems cleaner than what it used to be, but that could be in my head.
But I definitely see, more pieces of the thing. And what's this down here?
Where?
Right here. Can you see where my mouse is? Is that something you guys can see?
Oh yeah. What is that? Fucking thing looks red. What is it? Here, can you blow it up?
I can't when I do it like this. I might be able to on our stream.
I mean, that looks like a giant ass piece of red shit right there. Like I can blow it up, like just blowing up my screen, like the full screen.
Oh, I have to take it out of full screen. That's what I have to do. And now I can blow it up. Now you guys can see it, right?
You see what she's pointing at? What is that thing?
I don't
Is
know.
that a red Solo cup? I kid, but I mean, Jesus, is that part of the? I've never seen that. Have you guys seen that? So somebody says the reflector in the bumper, which is
All right. That could be so.
that very well could be exactly what it is.
I feel like someone, if it was a piece of the taillight, somebody would have.
Yeah, I mean, there's no way that would have it would have made it to this point.
Right, but there's this big piece here. It's hard to
All right,
tell.
when it pulls out, I want to look for the partner reflector on the
Other
opposite side.
All right, so I'm gonna make this big again. And
Particular pause portion of the video, Sergeant, what, if anything, of significance do you observe within the still shot of this portion of the video 153?
The portion of this video in the still shot presented identifies a missing, damaged rear right taillight, exposing the white light coming from the right side of that taillight.
And if you could, using the laser pointer before you draw the jury's attention to what you're talking about as far as that area of the defense. Now, earlier in that video, did you observe the defendant's vehicle coming close to or coming into contact with Mr. O'Keefe's vehicle?
Big answer.
And as far as Mr. O'Keefe's vehicle, at least from this video, what, if any, damage did you observe to Mr. O'Keefe's vehicle?
No damage.
As far as the ground area around where Mr. O'Keefe's vehicle is parked, specifically the rear of that vehicle, what, if any, red pieces or anything did you observe on the ground around Mr. O'Keefe's vehicle?
Nothing was observed.
so I found it interesting. She let him answer that when the jurors can see with their naked eyes whether there's anything there or not. And you'll also notice that Lolly asked a compound question. Did you see it come close to or come in contact with? And he answered yes.
It's coming to your breast.
All right,
There
I
it
don't,
is.
wait, back it up.
Back it up. All right, I got to play it again.
Can you do it in slow-mo?
I think so, yeah. Oops, don't look, Bob. Don't look.
Wow, she thought she thought
I
she
did.
was tricking me. She thought she had me there. The people are in the chat. I think she's playing at 1.25. People that know, they know, man. You're
I
not-
know. I figured they knew. I just figured you didn't. All right, here we go.
Old man Mata. Oh yeah.
I might have put it to that stuff.
I don't see it. What model Lexus is it? I'm just gonna pull up. I think it's a 21. I want to see like that. That's an easy question to answer to see if it's got reflectors in the bumper. Like our Audi does not have reflectors in the bumper. I don't think it might though.
All right, so wait, my notes say that he can't say. Oh, okay. All right, so then they go on and they show the videos from John O'Keefe's house when they go back, and this would be the period of time where Karen is said, "Can I come back to the house?" And you know, like there's this whole thing. She didn't really do anything. She didn't talk to anyone, and they basically show the video that like John O'Keefe's brother stayed in the car. So I think they're saying, you know, like that she never intended this to be, you know, like a long trip. And then they talk about how John O'Keefe's brother is cleaning off the car. And they go specifically, he asked the question, but he never cleared off the rear passenger side, which I don't understand, you know, what he thought that was um ever
Why that was significant?
right. Like
I have confirmed that there is in fact 2 reflectors on the bumpers of the 570 Lexus. So 2021 I put in. I think that's what her year is. Oh, 2020. Let me see. I'm sure that they still have it on that as well.
all right. Then he pulls back this one again.
The rear of the vehicle. Have a moment, John.
Yes.
And this is a still frame.
And sorry, you look up on the screen now, if you could direct the jury's attention with that laser pointer to the area of the.
Definitely has bumper reflectors on the bumper.
Now, this to me looks exactly like what we showed yesterday, that little piece that was missing when she put together the bumper, the thing that I called a mic drop.
When's that photo from?
That was the still frame of the same thing that we just looked at of her pulling out.
From when she left John's at 5:07 a.m.
Correct. All right. So you're about to be up.
I'm
right?
ready. I got it queued.
Okay, so the next thing that he does is basically go through a long, drawn out thing about how many drinks she had and where she had them, and ultimately circles back to it today to establish that she had 9 drinks.
Now I want to discuss this. So we see, here's my thing. Like that does not help a case in terms of intent for second degree murder. It to me that kills their ability to be able to have this woman who's thin as a rail, who's got MS, who's got Crohn's disease, who drinks 9 vodkas. I mean, if you all ever saw Allie drink 2 bourbons, she's shit-faced after 2 bourbons, like shit-faced. Like 9 in, she is not going to be.
It's much easier. Sorry, go ahead.
Vodka. Oh yeah, the tequila. You handled that pretty well at CrimeCon.
Somebody did say they thought the CrimeCon drinks were watered down.
Oh, I'm sure they are. And incredibly expensive. But you know what I'm saying? I don't see in what world the Commonwealth and Lally in particular thinks that having her shit-faced helps him move the needle in terms of proving intent, because you know they get into it on cross with respect to the ring camera being deleted. We know what their theory is. We know that their theory of her is that she purposefully hit him. She went back, she deleted video, ring cam video, you know, like 2 hours worth. And, you know, that she's sitting there laying on the couch. She doesn't even go up to the bed to sleep. She's staying there all night, like hatching plans. All right, at 5 o'clock, I'm going to call Carrie and I'm going to call Jen, and, you know, and I'm going to be hysterical, you know, like this, cooking up this whole thing. And I just don't know, unless it's a situation where you have somebody who, I mean, there are certain events that happen wherein you're intoxicated that snap you right the fuck out of it. You know, like a lot of times you could be pretty, like a little buzzed. And if you're unfortunately pulled over by a cop, you're going to sober up a little bit. It's like that adrenaline flow can certainly counteract alcohol to a certain extent. I don't know if it can counteract it to the extent that the Commonwealth is hoping, but I don't know, man. It's interesting. But I don't know that she wasn't just ordering the sodas and lime and then dumping the shots in there, because otherwise she's getting doubles, because it's always the glass and then the shot glass, which to me would mean that she ordered 4 drinks, because that happened 4 times, not 9 times. You know what I'm saying? You're muted.
Whatever. She ordered drinks. She didn't order drinks. Like you said, I mean, if she's that drunk, how's she plotting all of this? And I thought I had a picture of when they put together the reconstructed thing.
I mean, back in my drinking days, and I've been a non-drinker for 4 years. I mean, towards the end of it, I was browning. I was a bourbon guy, man. I could I was still functioning. I was still talking and walking, and we'd be out, and Allison the next morning be like, "Oh, you remember this?" I'm like, "I have zero recollection." "Oh, you remember we went to this bar?" Not any recollection of it whatsoever. And I was upright, speaking, obviously probably not well, but when you're blacked out, you're blacked out. You have no recollection of it. So, if I'm in that situation, in something like, I keep trying to explain to people, for folks out there that have been in an automobile accident, like I've hit 2 deer. It's slow speeds, and I'll never forget what it sounded like in the car. It was an enormous bang. Like like 12 miles an hour, I hit a deer and I killed the deer and trashed the front end of my car. Granted, it was I think it was like a 300M or some shit. It was whatever Chrysler 300 had the real
All right.
low. But my point being that you're going to hear it. It's an important distinction, because we're trying to figure out, because the real crime could be that she hit him, she knew she hit him, and she left him there, not purposefully, but on accident. If she I'm using on for this particular circumstance. It's an ongoing battle in our home, whether it's on or by. It's a real pet peeve for Allison when people said on accident instead of by accident. So, but my point being is that if she struck him, even if she's blackout drunk, that sound is so startling that it might have snapped her out of whatever stupor she's in, to the extent where she knows that she hit John or something, and then just takes off. You know what I mean? Like, maybe she doesn't think it's John. I don't know. It's like all this shit's going through my head as this trial progresses.
And before I turn it over to you for today, I just wanted to bring this picture up. This is the recreated, what the forensic people did to recreate the taillight. And these are the pieces they could never find and that they couldn't recreate. Now, if we go back to that last still photo, and I do have the exact timestamp. So 6:55:35.
Oh, Joe Schmo's a non-accident person. You're on Allie's shit list, Joe. I can just tell you that right now.
I don't know. To me,
Catherine says Allison is correct. It's by accident. Charlotte, by accident.
it's not you don't.
Fire says,
Don't do something
accidentally
on it just means sort of like you're doing it on purpose. It's like you do something by accident.
Well, I could tell you that I've obviously Googled this during
Right,
our
they have added it to the diction. It is now appropriate, but it wasn't initially.
Your constant berating has forced me to start using by accident all the time, but it was against my will.
So I don't know. It looks very similar to me. It looks very similar to me.
It does. It does. I mean, I like it. When I looked at it, I felt like there was a piece of the taillight missing. And I don't allow the noise from either side to get to me ever. I'm always going to form my own opinion based on my own observations, period. I don't give a shit what anybody's saying. I've got my own eyes and my own brain. So when I'm looking at that, the problem with that image is that I can't see the
Can't
other side
right.
from the, you know what I'm saying? So it's like, I don't know if that tail light just looks like that, if it's got that gap. I mean, when you look at the
Well, no,
entire
this would
assembly,
This would be the piece that broke
right?
during the backing up. That's the whole thing. That's why they don't have that piece, because it happened on John's driveway.
Because the short that I made, where I was discussing this exact issue, where I was saying that the defense needs to recreate this exact moment in time to show, most importantly, that the tail light can make contact with some portion of the traverse at that angle, whether it be the traverse itself, whether it be the wiper arm, whatever the case may be. But I think that it was important. But today, after we see what we saw, and I'm shocked that no one in the entire internet world that I'm aware of ever came up with the idea of focusing in on the wheel, because you definitely see I mean, he had to testify he saw the wheel move.
Stop giving. What about people who don't know this
Oh,
yet?
oh yeah. Spoiler alert. Spoiler alert. Just kidding.
So that being said, Bob and I had debates, like when we watched this video over and over. Bob said he thought the car moved, and I said I don't think it moved. So now we'll circle back to this on cross. But go ahead, Bob, you're up. Start at today at 29:10. So we're still a little bit more of direct.
Okay. All right. I gotta stop the screen share, change it up. Go right here. All right. I should be right where I need to be. All right.
Videos that you observed.
Can you guys hear it?
As far as, do you know how those cameras work as far as when they turn on and when they turn off?
My understanding is that Ring surveillance video is triggered to be recorded. My understanding is that
How those cameras observed. From the videos that you observed, let me ask you first, as far as, do you know how those cameras work as far as when they turn on and when they turn off?
my understanding is that Ring surveillance video is triggered to be
Ring
recorded
expert.
motion.
What?
So if the camera detects motion,
He's a
What?
ring expert. He's an expert
He's,
of ring.
I told you he's jack of all trades, master of none. That's his
Expert
thing.
of everything.
Yeah.
which is constantly live monitoring, and motion is detected, then that video is captured to a cloud-based system that retains that footage.
And from your review of those videos, what kind of motion would set those off? Like what kind of things would be recorded from the driveway camera?
The activity in the driveway, such as a person walking through, bird landing, a vehicle pulling in, individuals,
Walking around in the Sally port, which they were the entire time. So Jinxie, you just threw up that. So it's well documented for the last month that I've put out this third theory, which is similar to Jinxie's, which is that what if O'Keefe got out of the car? We've had multiple people talk about how slippery it was out there. You're getting that fresh, like little layer of snow right there. He gets a double foot, both feet out, slip. That wound on the back of his head looks exactly like it would look like. And I posted this, like, I found a GIF or a GIF, whatever you want to call it, of a guy slipping, both feet out. And that part of his head is exactly where it hits. And so same thing, but that he gets up, that would cause the raccoon eyes. There's no question about that. Anybody who's in medicine will tell you that. But like, I presume that he's not knocked out cold at that point. He's stunned. Obviously he's concussed, which I think also plays into the vomiting, but then gets on all fours, falls again, slips again, gets the egg on his head, stumbles over to where he's ultimately found. And in terms of the injuries on his arm, the thing that I've never, when we had Andrea Burkhardt on, and she mentioned the fact that she wants to see if the ME is able to tell if those wounds happen post-mortem, because you can tell when injuries happen
We're
post-mortem.
doing
as
a bad
opposed to-
job of keeping this short. We're gonna.
Oh,
we're
yeah, I mean, dude, we're never short. We're never short. That's not our, like, we try our best, but we're long-winded people. So, all right. But that's the theory I've been throwing out. I think that there's a third theory. That's my bottom line. But Google 34 Fairview and look what is just behind that house. A massive, massive nature preserve or some kind of wooded area. Bobcats are indigenous to that. Look into it, people.
Moving around in the driveway and so forth.
The search warrant that was applied for was any and all videos between January 24th and January 30th, correct?
For one of the search warrants, that's correct, yes.
And with respect to that time frame, what, if any, activity based on information that you had received was not available or was not shown on those Ring videos?
The data returned had video that would have been captured from the defendant arriving home after midnight on the 29th, after she dropped Mr. O'Keefe off at 34 Fairview Road. That video was not present in the data that was returned from Ring.
0.25.
There was,
What, if any, other video in addition to that one was not present?
Nice.
there was also video missing from the defendant showing Ms. McCabe and Ms. Roberts the damage to her right rear taillight.
And
Allison's
what, if any,
making me do
follow-up, or what, if any, inquiry was then done with regard to Ring as far as those types of videos or deletion, or how those videos could not be present?
Correspondence with Ring produced information that
Sustain.
Let me ask this first. Was there follow-up with Ring in regard to those videos?
yes, there was.
And was there ever anything produced with regard to those videos or those timeframes from Ring?
No, there was not.
If I could turn your attention over to your time in Dayton, just in reference to subsequent to that later on, what, if anything, did you receive, or what, if anything, did you request, what, if anything, did you receive from the Dayton Police in regard to January 29th, 2022?
Okay.
I communicated with the Dayton Police Department requesting documentation from their officers' calls for service at our request,
You can go to 30
and log notes,
Where?
33.02.
Let's see. 30. You said 3302?
Regard to those 911 calls.
yes, authored by Officer Barrows.
Oh,
Party again, correct.
Wrong way.
At some point that morning, where did you go?
During the morning hours of February 3rd, we planned to meet at 34 Fairview Road. Myself, Trooper Proctor, and Trooper DeChico arrived at that location in order to conduct a secondary search of the area as the temperatures were turning and the snow was melting naturally. We decided to do another search for articles that were now, we realized and learned, were missing and could be of evidentiary value and aid in the in the investigation.
And with respect to going to 34 Fairview Road, what, if any, tools or what, if anything, did you bring with you, you and the other troopers, in regard to conducting that secondary search?
I requested the troopers bring shovels, rakes, anything like gardening items that would help them to dig through the snow and locate any missing items.
And as far as the temperature change that you're talking about, how precipitous the change are we talking about?
The temperatures went above freezing, so the snow did begin to melt, and it was significantly warmer compared to the 18 degrees the night of the incident.
Now, you mentioned items of evidentiary value that you had learned of and were looking for. What, if any, clothing items, Mr. O'Keefe, were you looking for specifically on February 3rd?
We were specifically looking for Mr. O'Keefe's baseball cap.
And in addition to yourself, Trooper Proctor, who, if anyone else, did you notify, who, if anyone, from any other unit within the state police responded that day as well?
We requested the assistance of the Crime Scene Services section of the Massachusetts State Police, and Trooper Evan Brent showed up to assist us with documentation of the location and the evidence that we were hopefully going to find.
And from those, Trooper Brent arrived and took photographs, is that correct?
That's correct.
And when was it that Trooper Brent arrived in relation to your arrival?
So you can go to 106.
I believe he was already present when we pulled up, but I'm not sure to his exact time of arrival.
Go to 107.
106:47. 106:27. Whoa, whoa.
You
Really?
said 106:27. Yeah, we were.
Oh, that
This is
then-
only a 3-hour day of court.
oh, then I lied. Sorry. Secondary search, go to 4114.
Okay.
And I just want you to tab through the pictures. Like we don't need to actually listen to anything. So these are the pictures of everything that was found on February 3rd.
Okay. Can you guys see that? I'm in full screen, so I can't make it any better.
Just keep hitting the thing, it'll get better.
Okay, so this is February 3rd. Oh, yeah, that's better. Oh, it's getting brighter too.
So everything was found between the little electric box and the flagpole, and then we'll get some other stuff that's closer to the fire hydrant.
So you guys can see the flagpole here, right? And then the electric box. So right in between that area.
Are you putting your mouse on it?
Yeah, did you see it?
No, I thought it worked when we put our mouse on it.
Y'all can't see that? Like my little
No,
mouse right here?
I've been doing the same thing this whole time.
I did see it when you did it, I thought. Maybe that
Oh.
was my imagination. I don't know.
All right, arrows.
Is with no. I do.
What do you recognize that?
Keep going.
That is a clear black and another piece of
Exhibit 474. You recognize that?
Is this still on the
Sir,
third?
you recognize it?
Yep, all of this is on the
Sir,
third.
do you recognize what's,
property.
before you haven't had a chance to review those?
I have.
Do
Oh,
you recognize what's depicted in those photographs?
pause it.
I do.
So I just found it difficult to tell, where the things were picked up and, what they correlated into. On the third, there were, I think, let me see, I got to go back and look at yesterday's. So on the, oh, that's glass. There were 14 pieces on February 3rd that were recovered. So that's what they are going through. Now, if you jump to where were we today? Sorry. 5337.
Okay.
So now this stuff has to do
Do you
with
have the same straw?
the glass that they found.
Ms. Gilman, if I could have 7692.
So they found that
Sergeant,
straw.
do you recognize what's up on the screen? It has now been marked as exhibit 492.
I do.
And what are we looking at 492?
Piece of plastic next to a measuring ruler that's provided for comparison and by the crime scene photographer to document the item.
So that one's
And Ms.
found.
Gilman, if I could have 7695.
You can
For
arrow.
the record, this is now exhibit 494. Sergeant, what are we looking at 494?
It's the same item,
Recognize what
pieces of
introduced and moved next exhibit.
All right, so go ahead and pause it.
Okay.
So that's the street where they found the straw, and then you think about where all the pieces of the taillight are, and it's hard to reconcile. So now go to 10404. And this is still February 3rd, still things they found on February 3rd.
Now, Allie and I were having a discussion in the car tonight, and I want to verify it.
First time, I'm certain, I went back through all the testimony, I've got all my notes. February 3rd is the first time they found any pieces of plastic.
Okay, so the person who tweeted at me that, when the Lexus came into the Sally port, that's irrelevant in terms of when they found the taillight, because people are like, oh, well,
They did the
how
search.
did they find taillight on the 29th if the Lexus wasn't in, if the search at 34 Fairview, the evening search, when they came back, how did they find taillight there if the Lexus wasn't already in the Sally port? So what you're telling me definitively is that they recovered no taillight on the 29th, correct?
We covered it on February 3rd, which is one day after.
Yes or no answer. So what you're telling me is definitively they did not find any taillight on the 29th.
Correct.
Thank you.
All right. So, but I did want to say they found it on the first time they found it is on the 3rd, which is one day after the search of the vehicle. So we saw two videos that we rewatched today. One that was bright lit and is inverted. That was on the 29th. And then we saw that really dark one. That was February 2nd.
Yeah, but all I care about is that they had access to the vehicle before they started finding taillight. That's all that matters. Like in the world of planted evidence, you need that to be in place. They have to have the vehicle in the sally port before they find the taillight at the property.
Correct. Let's go.
Okay. You want me to play it?
Are you at 10404?
And Gentlemen, if I could have 7729.
I don't think so.
Well, I was at 104. I was at 104.22. So you 10. All right, here 104. That's what you're gonna get.
For the record, this is now 0520. Again, Sergeant, if you could direct the jury's attention to what, if anything, of significance you observe in this photograph.
I observed a shard of glass next to a measuring ruler.
And gentlemen, if I could have 7729. For the record, this is exhibit 522. And again, Sergeant, if you could describe the jury what we're looking at here.
It's a larger piece of red plastic with black molding around the edge, located next to the telephone switch box on the grass area at 34 Fairview Road.
Straws in the street.
And gentlemen, if I could have photograph 7733. For the record, this is exhibit 526. And Sergeant, from this photograph, what, if anything, are we looking at here?
This photograph here depicts the area which we are excavating during the morning hours of February 3rd, 2022. As the shovel works its way towards the grass, my laser pointer is directing your attention to Mr. O'Keefe's hat that was compacted underneath the snow on the ground.
Now, as far as this photograph is concerned, does that accurately depict the depth of the snow that you were digging into and sifting through on the morning of February 3rd?
It does.
That, again, is several days after the blizzard of January 29th, correct?
That is correct.
And Ms. Gilman, if I can have photograph 7740. For the record, this is exhibit 530. And again, Sergeant, if you could describe to the jury what we're looking at here.
We're looking at Mr. O'Keefe's hat on the grass, pressed down and compacted to a flat surface underneath the snow, which has been excavated around it.
Thank you very much. Ms. Gilman, you can take that down.
What number,
Thank you, Mr. Ross.
what number are we at?
Sergeant, on February 3rd, 2022, is that the first time that
What
you
time?
before Fairview Road?
Yes, it is.
And
106.34.
with respect,
Okay, perfect. Keep going.
Keep going.
if I could turn your attention briefly to the following day of February 4th. Did you have occasion to go back to 34 Fairview Road on that day?
Yes, I did.
And what brought you to 34 Fairview Road on February 4th?
Having excavated those items on the 3rd, I directed the troopers in my office, who obviously reside in the communities around us, to make a point to travel by that location every day on the way to work and every day on the way home. The purpose of that was to see if anything else was to reveal itself as the snow naturally melts away and items could present themselves. So on the February 4th, as I am traveling to work, I diverted my typical route of travel to go by 34 Fairview Road. Just prior to my arrival, I received a call stating that there was 10 police representatives at the scene and more items have been revealed due to the melting snow, and that I should come collect those items. I was down the street. I arrived and collected the item that presented itself.
And if you recall, that item that you collected on February 4th, was that located on the lawn, on the street, or something else?
It was on the lawn.
Now, with reference to your collection of these items either on February 3rd, February 4th, or on any sort of subsequent date, how were they collected and what exactly did you do with them in reference to the seizing of the items and storage of the items?
Each item that was collected was placed in a evidence
Closet.
paper bag. The collection was done by utilizing.
Damn.
Oh, I'm like, can he hear me? All right. So he goes on to say that I found it strange that everybody's driving by, but Proctor's the one that finds, you know, all of the significant things that we heard about yesterday. He goes on to testify that he found things February 3rd, February 4th, which they didn't say what the item was on the 4th. I don't understand that. And February 10th. And he said there were like 14 pieces on February 10th. But yesterday, when they were giving us the times, and I just don't understand and the dates, they said on February, am I looking at yesterday? No, sorry.
See, there's people in the chat. Jimmy McNutty is adamant that O'Hara testified that the search and rescue on the 29th found a few pieces of taillight.
Well, the woman who testified yesterday to putting the whole entire taillight together, she went through every evidence bag. So I tell him to give us the
EV numbers.
or the timestamp of when that happened, because the woman who testified yesterday, I wasn't watching that
You're
day.
talking about the first witness, the
Who put
blonde,
together
not the one with the glasses.
this. She testified to every evidence bag, which had the data collection and the and who collected it, and what those and what pieces were used to put together the taillight. It was February 3rd, February 11th, February
I mean, I'm always going to go by chain of custody rather than what some cop said on the stand, but we're defense attorneys.
okay, so
Mandy put Jimmy in time. Jimmy's just adamant. You know, he doesn't name call.
February 3rd, 14 pieces of apparent red, clear, and black
You're the
plastic.
mod.
And on February 8th, there were
It's been awful. All we have are the envelopes, though. The envelopes are as good as we're gonna get.
7 to 8 pieces, and there was a 4-inch recovered from the Albert House. February 11th, there was February 11th, they recovered evidence bag 7-15. I'd have to go back up to 715 because I've got it written in different places, but they gave all the dates. There was no pieces of plastic, according to the woman who inspected all the pieces of plastic, no pieces of the taillight recovered before February 3rd.
Okay, so like what we need to delineate, because there's a tasty debate going on in the chat. Jackson has clearly said during testimony that there was zero taillight found on the 29th, but we do have people are adamant that O'Hara testified that they did find it. So
they found glass. They found glass. So what did O'Hara testify about? Was she the hair person?
no, O'Hara's a guy. O'Hara was like the first search and rescue guy. Like he was.
Well, none of his pieces made it to the forensic lab to be put together.
Right. Well, and O'Hara was the guy who said that there were 3 cops who he didn't know who they were. Remember, I was telling you that? He's a trooper.
So then O'Hara was mistaken.
Right. I mean, that's what I'm saying. Like people are taking like O'Hara as his word is the gospel. What I'm suggesting to you is that we have to go by the evidence envelopes. As shitty as the chain of custody is in this case, the one thing that we have that at least has writing on it are the evidence envelopes, and those will say when it was collected.
and it's what the woman used to put it together. So maybe I'd have to go back and look at this O'Hara's testimony, but maybe he was in his mind thinking the glass pieces that they found were plastic, clear pieces of plastic.
But the clear plastic, would that be taillight or would that be a glass? Like, what do
That would
you
taillight. I'm
taillight,
saying
right?
that maybe he's confusing the pieces of glass in his mind as being pieces of plastic. O'Hara. I don't know. We need to revisit it. But on direct and on cross, everybody said the first pieces were February 3rd.
Okay. Aside from O'Hara.
He
So
just
that,
right,
that's
but he just put all 14 of those pieces into evidence as February 3rd. This trooper did.
okay. So he's contradicting O'Hara. All right. Do you want me to keep rolling here?
Now I forget what number, what
We're at 108.52. Or here he's still talking about pictures, right?
wait, hold on. We're at
I'm
today.
showing you documents section, look at that section and look up.
No, I want to go to, so he just testified.
We're at 110.34 right now.
Well, let's skip to 118.33. And so, but I do want to note that he did testify that he found things on February 3rd, February 4th, and February 10th. February 10th was
Move
not.
on from that, if I could bring you back just one last time.
Is that him
Videos from
personally?
one
Because there
Meadows
were
Ave.
other
Testified earlier
troopers
that,
that found shit.
There's no video that you observed of the defendant, Ms. McCabe, and Ms.
That he was there and present for when items were collected.
Okay.
In the 3rd, the 4th, and the 10th.
Okay.
So now you're at 118.33.
Yes.
We're going back to the ring camera, people.
Oh, wait, 118.33.
Yep.
Testified earlier that there was no video that you observed of the defendant, Ms. McCabe, and Ms. Roberts looking at the passenger side taillight area of the vehicle, correct?
That's correct.
Was there any video of the defendant, Ms. McCabe, and Ms. Roberts actually leaving from One Meadows Ave on that morning of January 29th?
There was not.
All right.
Now, as far as the videos that were not there, as far as the defendant, Ms. McCabe, and Ms. Roberts leaving, the next video depicted Mr. Camerano arriving at the residence to pick up Ms. Furbush, correct?
Yes, that's correct.
And with regard to the missing video of the defendant arriving at One Meadows Ave on January 29th, sometime after midnight, the video immediately preceding that, again, would have been Mr. Camerano arriving and picking up his daughter from One Meadows Avenue sometime around 11:30, correct?
That's correct.
Those videos were both present, correct?
That's correct.
All
I
right.
can bring you back to February 3rd,
Pause.
2022. On that date, did you have occasion to meet with?
So he goes on to talk about that he went to the Albert house. He interviewed Nicole Albert. Brian was present. He was there in the room. He talked about how they do interviews in pairs, usually with a local person, but Canton was conflicted out. So they did it with 2 troopers. And then he goes on to say how in his vast experience, an interview to be done correctly for someone to explain everything they know is 45 minutes. So I find that just shocking. I don't know why that's so important. Maybe someone else does and I'm missing it. It's something that has been discussed before. But I mean, if you're telling me the story of how, you witnessed the mailman throw an egg at the house, that may take all of 5 minutes. If you're telling me the whole story of, God knows what could take 3 hours. I mean, it's just bizarre. So then we go to 126:14.
Okay.
And this is the statement of Karen Reed in the police department. Now, I thought I recalled there being in this statement initially something about
It
a
was
fight
longer.
in the house. Yeah, that she said something about there was a fight inside the house, that they beat him up.
Right. There absolutely was there. So remember,
Right.
that's when Canoni said she was going to take it, listen to it over the weekend. They weren't going to show the video because she was in cuffs. And this is ultimately what she allowed in.
Or this is what the prosecution put in.
Right.
if we're all on the same boat, right? My tail is correct and John was pulverized.
And that's it. So now you can skip to the cross, which
Do you know where that starts? Oh, this is it right here.
actually the girls sent me the actual timestamp.
Specific to the ring video that y'all talked about this morning. Do you have that in mind?
I do.
The search warrant that produced, and just so we're clear, I'm talking about the specific ring video or series of videos that were associated with One Meadows, John O'Keefe's home.
Okay.
Okay. You didn't write the search warrant for those ring videos, did you?
I did not.
You were not the affiant for those search warrants.
I was not.
Who was the author of the search warrant and the affiant?
It was Trooper Mike Proctor.
Who received the actual ring video or videos from the Ring Corporation?
It was Trooper Mike Proctor received it.
And who ultimately either logged those into evidence or controlled those once they were received from the Ring Corporation?
I believe it was Trooper Mike Proctor.
And ultimately, Sergeant Buchhenik, you did note that in addition to just the physical videos themselves, that login information and login keystrokes, et cetera, were requested from the Ring Corporation as well, correct?
There was discussion with
Well-
Ring asking for those logs.
I'll call it, is it correct to say an activity log?
So, and then you should rewind it like 10 seconds or something. But I just wanted to note that what I thought what Jackson did is sort of masterful, because on cross-examination, you're usually asking leading questions. Proctor did this, right? Blah, blah, blah. No, he chose this point to give an open-ended question so that the words and the answers are coming right from his mouth. Mike Proctor. So I just thought that was,
Yeah, it's better to have the witness saying it than him asking it, for sure. I agree. Wait, you want me to kick it back 10 seconds?
yeah.
I mean, the significance of this is this goes right to, the theory that Karen Reed deleted the Ring camera video, like these portions of the video camera. So this is an important part of the cross for certain.
Oh, correct?
There was discussion with Ring asking for those logs.
I'll call it, is it correct to say an activity log?
That's what was requested, yes, activity log, yes.
So ultimately, the activity log would show who logs in, who accesses the data, things of that nature, correct? Or at least that was the hope.
That is what was requested.
It would also show logging in and executing deletions, manipulating the log files, things of that nature, correct?
That is what was requested, yes.
When you reviewed those log or activity logs, there was no evidence revealed that my client ever logged into that account, correct?
There was no activity logs provided by Ring.
So you have zero, hang on.
Right, so he searches through his shit for a
So
second.
right here, when we first watched it,
That
like,
Ring
what the hell? Why would he ask a question like that if they didn't
Is it
have it?
true that Ring contacted Trooper Proctor and indicated that they had created a Dropbox folder that contained the evidence that had been sought in the search warrant?
Objection.
Sustained.
Isn't it true that the search warrant return specified account information, video recordings, and number 3, activity logs associated with video recordings are all times displayed in UTC?
I'm not aware of that, no.
Do you recall that activity logs were in fact provided from the Ring Corporation?
I do not recall that, no.
May I approach briefly?
Yes.
Take a look, Sergeant, at that paragraph, which my finger's on, it's like the 3rd paragraph down the middle of the page, and review that.
Wait. I wouldn't skip through this because that
He's reviewing it. He's
I
reading
know
it.
it took him so long.
Well, we can see how long. It's 5-second blips I'm making. So it took him
Does this
about
refresh your recollection as to the items received from the Ring Corporation?
That is the first time I saw that document, so it does not refresh my recollection. I simply read it.
So
now that is a professional witness. That is a witness who has testified, because that's how you answer the question. So if you are going up to a witness who's claiming that their memory is exhausted, and you ask them if there's something that would refresh their recollection, and you hand them the document and they read through it, and you ask them the question, which is required of us to ask, does that refresh your recollection? If that person says no, it basically stops you in the water, because the point is that you're not supposed to be forming a new memory based on the reading on the stand. It's supposed to actually trigger a memory in your head wherein you remember either seeing it before or knowing that it existed. So
But
the way that he was very crafty, the way that he answered that.
as crafty as he was, Jackson's craftier, and he knew how
Indeed.
to get that in anyway. You're the supervising agent. You've reviewed the file. Why don't we just go right to the documentary proof?
It's a significant moment of impeachment because it's a big accusation. It's a big accusation in terms of Karen deleting this Ring camera, and then Jackson obviously is going to slip it into Proctor. Proctor had his hands on all this stuff. That's where he's going to lead the jury. And again, remember, the defense has to prove nothing in this case. All they have to do is pick apart the state's theory enough so that it raises reasonable doubt. You have to be the judge of whether or not that's happening. And with Buchhenik, I'm just telling you, having done this for 20 plus years, this cross-examination, which we saw today, was very effective.
Do you have a recollection, as you sit here, that in fact, during the course of your investigation, the three items that you received from Ring Corporation were the account information, the video recordings, and, quote, activity logs associated with the video recordings, all times displayed in UTC?
To the extent of its availability, as it says in that document.
Okay. The long and short of it is, during the entire course of your investigation, you never revealed that investigation never revealed any evidence whatsoever that my client ever even accessed the account information for the Ring account associated with this search warrant, correct?
Nothing provided by Ring proved or suggested or proved any evidence of that type of activity, no.
That is a butchered answer right there. Like that, like probably the most important question in this line of questioning, and he just flubs it completely. We're all sitting here trying to get the truth.
I don't think he flubbed it. He said the truth. There was no evidence that she did anything.
Right, but he goes from proof, it's just let's listen to it again.
The entire course of your investigation, you never revealed that investigation never revealed.
He's trying to choose his words so carefully.
Even accessed the account information for the Ring account associated with this search warrant, correct?
Nothing provided by Ring proved or suggested or proved any evidence of that type of activity, no.
Trooper Proctor, you were notified.
I am not Trooper Proctor.
I'm sorry. No, you're not. Sergeant Buchhenik.
Sergeant BUKHENIK.
How do I say it?
BUKHENIK.
I'll give that a shot.
It's fine.
Buchhenik?
Yes,
Is that better?
that's better. Thank you.
If I screw it up again, please. On January 29th, you were notified about a Boston police officer found gravely injured outside the home of 34 Fairview at about 6:40 in the morning. Was that your testimony?
That is not.
What time were you notified?
I was not notified it was a Boston police officer.
So you didn't have that information upon the first notification?
I did not.
Okay, what information did you have?
There was a male party in the snowbank, possibly of a heart attack.
At what point did you learn that the individual was in fact a sworn Boston police officer?
I do not know exactly when I learned that he was a Boston police officer.
I think it was during that day or the following day?
It was most likely that day, either. Yeah.
Fair enough. Trooper Proctor was ultimately assigned as the, what did you call him? Not lead investigator, but case officer.
That's correct.
He was assigned on the 29th, correct?
He was on call from 7 a.m. on January 28th until 7 a.m. on January 29th.
So his assignment was, he was assigned on the 29th because he was on call.
He was on call. His assignment took effect when the schedule came out back in mid-December.
Okay. Well, he wouldn't be assigned to this investigation until there was a need for the investigation, right? And that's all I'm getting to. I mean, once the call came in, he was the assigned case agent.
Once the calls come in, the person that's on call is automatically assigned that case.
All right. Did you personally, as his supervisor, did you personally respond to 34 Fairview at any point on January 29th?
No, I did not.
Did Trooper Proctor, at your direction or on his own, ever respond to 34 Fairview Road at any time on January 29th?
No, he did not.
Based on your initial investigation, and I'm talking about going way back, Sergeant, on your initial investigation, by 10 or 10:30 in the morning, 10:40 in the morning,
It had
it was
both.
your belief that Mr. O'Keefe had been struck in the face by a person. That was your initial understanding of the circumstances surrounding the investigation, correct?
No bones about it.
My initial understanding was that the defendant stated that she hit him. We did not know them.
You hadn't even met my client at that point. You hadn't interviewed a single witness by 10:41 in the morning, correct? Not one witness.
That's not correct. We had already interviewed the first responders.
Okay, when I say witness, I'm talking about civilian witnesses. So at 10:41, you hadn't interviewed a person at 34 Fairview or associated civilians associated with this incident, correct?
At that point, no civilians have been interviewed, no.
But at
So I don't know how many people actually watched the full day of trial with us as well. So if you did, you're getting my duplicative comment here. But I felt like, to me, what he's about to get into, the fact that this witness had interviewed the first responders before he makes the statement that is going to be pulling teeth to get him to admit, parsing every word, trying to avoid answering it. The fact that he had talked to first responders before he made the statement actually assists the defense. It makes it even more shocking that this is the statement that he makes, as you're about to hear.
"10:41, Sergeant, you contacted Good Samaritan Hospital to inform them that, quote, Mr. O'Keefe was struck in the face with a cocktail glass, end quote, correct?"
I do not recall contacting Good Samaritan Hospital.
May I approach?
Yes.
Take down that comment that's incorrect.
I'd like you to take a look at this document, and if you wouldn't mind,
Well,
pay special
it's,
attention to the
he's saying
page,
it's
the
correct.
bottom paragraph where it's tabbed.
That's not how a chain of custody is properly done. The moment that any evidence is collected, it's noted the time and the date. So
And it is. It's not up for debate.
it's not up for debate. That's not a debatable issue. But that goes to the investigation.
And this witness testified the date that he actually collected it and the date he collected everything. This, how long he's looking at this. He's having a heart attack right now.
He's not loving it.
The longer he takes to read it and realize he said it, the worse. Oh,
Gives a little head nod. There's to go. Shit, there it is.
damn it. How am I getting out of this? What can I say? It still says it. It's still there. Didn't go anywhere.
Yeah.
Nook is trying to steal all my snacks from starving to death.
After we got him that fantastic bone, what?
Yeah.
It's outrageous.
Pieces of cheese and bologna.
May I approach?
Yes.
Thank you, sir.
Still pulling teeth.
Having reviewed this, does this refresh your recollection that you contacted Good Samaritan Hospital and gave them an assessment, at least based on your investigation at that time?
That is not true.
What did you say to Good Samaritan Hospital?
I never spoke to Good Samaritan Hospital. That document is for the medical examiner's office.
I'm not asking you where the document's from. I'm asking you if the document says Trooper YURI BUKHENIK called back at 10:41 stating the case is now being treated as a suspicion.
The objection sustained.
But
Did you
why?
say- Did you call
Why did
back
she
to
subsume?
Samaritan
Like, I
Hospital
don't
and
understand
say
what's just
that the
why that was.
investigation was being treated
Don't
as a
get it.
suspicious due to a domestic situation? Did you say that?
I never spoke to Good Samaritan Hospital.
Did you say that there's a possibility that D was struck in the face with a cocktail glass?
Objection.
Sustained.
Did you ever contact anybody at any medical facility and indicate that the investigation was being treated as a suspicious, in quotation marks, because the victim appeared to have been struck in the face by a cocktail glass?
Objection.
Allow that. Did you ever say that?
Yes, Your Honor. Yes, I did say that to the medical examiner's operations desk.
Okay, so when I was asking you if you ever said it to an exam, you said,
hell
no, that's not
on,
true.
buddy.
It's never happened. You were correcting me on the fact that it happened at the medical examiner's office, not at this.
I responded and answered your question honestly, yes.
Okay, so honestly, you did, in fact, at 10:41 a.m. indicate to another professional involved in the investigation that the circumstance was being treated as a physical assault at that point, correct?
I communicated our suspicions to the medical examiner's office.
And that was at 10:41 or thereabouts in the morning, correct?
That's correct.
Your initial investigation during those obviously critical hours, the beginning hours, led you to believe that there was at least a good possibility. You indicated that you made a phone call, that it was a physical altercation that led to John O'Keefe's death, correct?
That's correct, yes.
What steps did you take, sir, to,
Positive
in
second.
those moments, to determine whether someone in the house at 34 Fairview may have been involved in that physical altercation that you suspected at the time?
As investigations develop,
Can we
we
pause it?
followed the evidence and
I was just
You need tiny hand. That's what you need.
too. I need tiny hand.
Here's tiny hand.
You found it.
Start
Oh.
with it.
So I just wanted to point out that this is why at least defense attorneys and probably most attorneys are always pointing out, like, you cannot think that you're going to get what you want or need from a police officer. It's they are designed to avoid answering the question. And yes, technically he's right? Well, but I didn't say it to them. But he doesn't just say the truth. He fights and fights and fights and fights, and then he fesses it up. And I think it
Makes him look slippery. It makes him look slippery. There's no question. Like, in a common person, a juror is going to look at that confrontation, if you want to call it that, and come away that one of these two people is avoiding answering a question. It's that simple. Like the law in terms of cross-examination is not rocket science. People use their common sense. They use their own experiences in life. And this is somebody who knows he said something. He's read it and is trying at all cost to avoid saying it out loud. It's that simple. Like, there's no way that the jury's not walking away from that exchange thinking, man, like this, like, why didn't this guy just admit it? Right? Because on its face, who gives a shit what his initial impression was? But he, the lady doth protest too much makes it seem nefarious. A cop's allowed to have an initial impression of what they think might have happened based on limited evidence that they've collected, So, but like when he fights it like that, it creates, I think, something in the minds of the jury that's not helpful to the Commonwealth. So Middle Eastern, so Sleuthy's timeline for 129, 5 p.m. motion to dismiss, page 7. Third paragraph says a subsequent second search was done by CERT that recovers 3 pieces of red and clear plastic after Proctor seized Lexus. So there we
all
go.
right. I want to look into it because I just find it strange that those 3 pieces of red and clear plastic were not part of the light.
The puzzle, right?
Right. She tested all the pieces. So where
Right,
did this thing go?
Right. So maybe they weren't brought into evidence through her because they didn't fit.
Right. And maybe he was hit by a different vehicle, or maybe, like she's saying, it's after Proctor sees the Lexus. But I have to say, the timeline said that they didn't get that Lexus to
Or
the
maybe those pieces aren't from a Lexus altogether.
right, because it's not what the woman used to put it back together. But
Well, let's call a spade here. 99% of defendants do not get a defense team like this in a case. That is the reality. Most defendants get a public defender, okay, who is not going to put like anything even close like this in terms of a defense forward. It just doesn't happen. That's why, people plead out to charges that they, for crimes that they didn't commit all the time, because when you look at the downside, if the state says, I'm going to make you a 2-year offer, I'm going to reduce the charge. Here's my offer. Okay. When they've got a public defender that doesn't have nearly enough time to look at their case, happens every day in courtrooms all over the country. Believe me when I tell you this. This isn't me trying to make some shit up. This is gospel that, you get a client and this guy's represented by a PD who just doesn't have the time to look at his case. When we get called by people that can scrape together enough money to hire a private counsel, like, yeah, I talked to my PD once, twice, maybe, in a year and a half. And it's no indictment on public defenders. It's an indictment on the system that they're overworked and they don't have enough time to properly handle cases. That's the difference between private counsel and public defenders is time. It's not intelligence or the fact that one is smarter or better lawyer or any of those things. I mean, of course that can be true, but it's not that public defenders are fake lawyers. They just aren't afforded the amount of time that you need in order to properly prepare for a case like this. So, at that time, and what I'm suggesting is that they don't necessarily know at that point in time that Karen Reed's hiring Alan Jackson and David Yannetti, who I can't imagine. Well, I actually can. This defense is in upwards of $500,000, probably more, probably much more. In terms of this has been litigated since 2022. And you've seen the pretrial work that's been done on this case, and you see this is a 6-week trial, at least, probably a 10-week trial. And from what I understand, Jackson charges $1,400 an hour. So you do the math. I mean, the point being that the state typically is not up against a team like Yannetti and Jackson in most of their cases. And to go back to my point, like on those plea deals that they make, where a guy's got a PD and he's looking at an 8-year bid on a class 3 felony or a class 2 felony, and the state offers, well, we'll drop it down to a class 4, which is how they classify them in Illinois, and we'll give you 2 years. It's going to be tempting because the downside is so huge, and that defendant has no absolutely like zero faith that his lawyer is going to be able to get the job done, and that he's looking at 8 years. They take the 2 years, or they'll take an offer that has no jail time, but we're going to hang the felony on you. It happens all the time. So,
but I do promise I am going to look into.
I can guarantee you she will.
Some plastic and figure out why the hell there was some plastic found, but it's not mentioned by the woman that put together the thing. So I'm gonna. Your comments are not going. 6 p.m. Okay, so that is after they're already like in the Sallyport with it and hovering.
Well, I mean, the interesting, and I did watch O'Hara's testimony, and I that's why I kept asking you when we were in the car. I'm like, are you sure about, like, because I had seen that, but the most interesting thing that I took from O'Hara's testimony wasn't that he found the three pieces of plastic, but instead was the fact that there were 3 officers who he could not identify. And we're talking about, this is the CERT team there. The state police are there in order to process the scene. Yet there's 3 cops that he does not know who they were. And they never get into it. I don't know if O'Hara knows Proctor. I don't know if he knows him by sight. I don't know if he knows any of the Canton cops by sight. I imagine that he might, but he didn't know who any of these 3 other cops that just showed up and started searching with the CERT team, with the state police. It's very unusual. Like, once the state police take over an investigation, you know, they're typically not going to want another agency meddling with their investigation. That's just facts. That's the reality how law enforcement typically does not play well together.
Statements made. The steps I took was Trooper Proctor and I proceeded to an eyewitness who was also present at the scene when the victim was discovered and interviewed Mr. McCabe.
And prior to that, prior to interviewing Ms. McCabe, by the way, that was at Ms. McCabe's home,
Yes,
correct?
they are. My dad,
That's correct.
public
Even though you
defender for
believe that there
15
may have been a
years.
physical
It is a
altercation,
great
you didn't ask
lawyer.
anybody to come down to the station. Is that right? Any of the witnesses?
That's correct.
And you did not seek to actually go to the physical location of 34 Fairview in those next few hours,
How much time?
That's correct.
or the next few days, correct?
Not myself, no.
As a matter of fact, Trooper Proctor did not either, did he?
No, he did not.
You didn't secure the interior of the house as a potential crime scene. You certainly know how to do that, right?
That's a compound question. Do you want me to answer whether I did it or whether I know how to do it?
Well, I'll ask the question. If you can answer it, please answer it.
Okay.
It is
Can you
compound,
answer that question?
I can answer that question.
Why don't you answer both of them then?
First portion is we did not secure the home as a crime scene. And the second portion, yes, I do know how to do that.
And you didn't, as a Massachusetts State Police official, you didn't secure the outside as a crime scene either, did you?
I did not know.
To your knowledge,
Albert, if you're late coming, yeah, we actually went through the that video that was shown yesterday. That's where we started. This is today's. We started with the direct from yesterday, and now we've moved to Jackson. So yeah, we did see that video. We all know what's going on with that video.
I appreciate it from one middle sister to another. I don't know. Do I count as I'm still a middle because
There's 4 of you.
right.
Yeah, I mean, there's 2 middles. That's all. There's still a first and a last. You and your brother are the middles.
Right. And then I'm middle to both my other sisters too.
So we did say that we did see that portion of the video, Albert, and thank you for your generosity. All right.
nobody else from Massachusetts State Police ever did either.
Yes, they did.
Yes.
How was that done and when?
Wait, pause it a sec.
When members of our office and the
Didn't comment on that, and I kept thinking about it and then forgetting to mention it. Like, why did it look like he headed towards the door and disappeared? Like, I didn't get that.
Yeah, I know. Well, I mean, this is what they were bitching about in the final pretrial hearing when they were talking about the missing portion of that video. We're getting into that on Monday. Jackson.
Albert, if you watch the beginning, we also talked about how in that garage there was a car with snow on it that had clearly just gotten in there because, like, or after all this started, because the snow had just happened, and then pulled out. But I don't know. I did think that was really strange. It's like he goes to the door and then boop, he's gone. So maybe that is something that Jackson will point out on Monday. On Monday.
Oh yeah, well, that's where it stopped with him with the flash drive, walking up with the smoking gun flash drive. So what a way to end it. That was a real cliffhanger today. All right.
CERT team responded to that location and secured the front yard grass area and processed it.
That was at 5:45, 6 o'clock that night on the 29th?
I believe it was earlier, but I was not present, so I can't testify to the time.
So you don't know personally what they did to quote unquote secure or not secure the crime scene. You know they searched it, but in terms of securing it as a crime scene, you don't have personal knowledge to that.
I was not present.
You never took any photos of the interior of the house, correct?
I did not know.
You never caused CSSS to go inside the house and process that house as a potential crime scene, correct?
I did not know.
No forensic criminalist at your direction ever went into 34 Fairview?
No, they did not.
Yeah, they're both pals.
And the people that you interviewed on January 29th, you already mentioned Ms. McCabe. The other people were her husband, Matt McCabe, correct?
That's correct.
and her brother-in-law, Brian Albert. Is that right?
That is correct.
And all three of them were interviewed where?
They were interviewed at the McCabe residence.
Now, yesterday when you testified, did you indicate that Brian Albert was not present in the home when you interviewed Matt McCabe and Jennifer McCabe?
He was not present in the dining room when we were interviewing each individual separately.
So if all three of them testified that he arrived before you arrived, they would all be wrong.
I did not see him in the home when we arrived, no.
I want to switch gears real quick to a couple of the physical items that you testified about yesterday, specifically the gray shirt, or the gray hoodie and the orange shirt. You and Trooper Proctor collected both of those items you indicated from the floor of the hospital at Good Samaritan, correct?
That's correct.
You testified that you and Trooper Proctor immediately bagged both of those items. They were sort of sopping wet, I think you said.
That's correct.
You indicated that the bags were so wet that you had to take the items back out of the bags and then lay them out on, I think you said, butcher paper. Is that right?
The items were soaked and wet. They were bagged, double bagged, to prevent leakage of physiological fluids and the moisture coming off of it. And then once they were transported to the office, they were laid out on butcher paper in order to dry naturally.
So you went from Good Samaritan directly to Dighton, correct?
That is correct.
And then you went from Dighton directly to the Canton Police Department, after which you had seized the vehicle, correct? And the phone.
We seized the phone in the vehicle in Dighton and then followed the tow truck straight to the Canton Police Department.
So at some point, if you had received or gathered the wet clothing at Good Sam, went from Good Sam to Dighton Canton PD, at what point that evening did you finally get those items of clothing out and laid out to dry?
It was late that night, around 10 or so.
So where were the items in the meantime?
They were stored in the back passenger compartment of my pickup truck.
In those double bags.
Correct.
Who took control of the items to then lay them out?
Never.
Late that night at the office?
I do not recall.
Is that you or Trooper Proctor?
I don't recall. I don't remember.
At some point, obviously, it was getting late. You'd been on duty for a long time that day. You went home at some point, correct?
At some point, yes.
Did you wait for those clothes to dry before you went home, or did you leave that in Trooper Proctor's hands?
No, once they were laid out in the processing area in the office, we went home.
Okay. Who would have controlled those items of evidence when you left?
Well, they're under lock and key within the secure area of the district attorney's office, so they're secured. Nobody's in physical control watching guard over them.
Who had access to that area?
Troopers in our office.
Meaning you, obviously.
Yes.
Trooper Proctor as well, correct?
Yes.
Ultimately, given the fact that he was the case officer, sort of in charge, he would have bagged those items up, been responsible for taking those items, tagging them, getting them stored wherever they needed to be stored and processed, correct?
As a case officer, he could direct other people to perform those tasks for him. The evidence officers in the office log in the evidence, and once it was dried, it was sealed up, bagged, and put into storage. As far as who actually performed those tasks, I do not know.
Well, yesterday, Your Honor, may I approach courts, right? There's a couple of minutes.
Oh, sure, go ahead.
Familiar.
Something up at this point. The bag on your left, which one is that, 437 or 438?
The bag on my left is 437.
437, okay. And you indicated that those items were bagged after the clothing was dried and then ultimately processed in, logged in.
All right. So Allie's right. We've still got, and what we'll do, maybe we'll do a short live tomorrow just to finish off this cross, because I really want to play through the entire cross. The cross there's a lot of big moments in it, which I think are critical to the case. Here he's making the point that these things didn't get bagged, that they were accessible, drying out for 5 days before they're actually.
And he's also making the point that they don't have the right type of log. Usually there is an evidence log. Every time evidence is touched, who took it out of the evidence locker, who handled it, who took it where, who walked it where, who sniffed it. For God's sakes, if the evidence locker is opened, it's usually referenced somewhere on a log. but I don't think you need to do. I don't think you need to do all of this for the purposes of this. I think you can.
Well, but I mean, just there's probably like we're not going to be able to skip through like the two biggest parts of it are coming. You know,
You know,
we've got the video, we've got the whole confrontation. It ends with the confrontation over the inverted
I
video.
think that's where we go, personally.
Yeah. All right. Well, let me look. So the bags go on for a little bit. Let me see what he's into here.
Sergeant, you didn't personally write a report about your conduct at 34 Fairview on either of those 2 days. In other words, you didn't go back to the station and generate a report.
This
yourself.
is important.
I don't recall.
This is where coming out of yesterday's
searches.
testimony on with him on direct, Lally had laid the groundwork through the collective knowledge doctrine, which I've explained a few times in our lives, which is basically cops can testify to work that other cops have done and have noted in reports, and or if they've observed interrogation videos, things of that nature. They have this doctrine called collective knock. Oh my God, I can't even talk.
Right.
Yeah, I gotta call it. It's been like 2 days of like no. So the collective knowledge doctrine is basically, you know, we're like he can come up and testify to what another cop did in terms of collecting evidence as long as he's read the report. So yesterday would you know, I came away thinking that Lally had just set the stage, because it was a shock to me to find out yesterday, frankly, that he is superior to Proctor. He's higher ranking than Proctor, and that, you know, and he was very careful to not call Proctor the lead investigator. I can't remember the case manager.
He just happened to be on call. So, you know, the on-call person is assigned.
Right. But, you know, and then he's saying, well, Proctor basically was just telling people what to do, what other officers what to do. So I really came out of the testimony yesterday believing adamantly that the Commonwealth wasn't going to call Proctor, which is a death knell to their case. There is no circumstances in which they are securing a conviction if this guy that the jury has heard so much about does not testify. But like Lally was setting it up where he didn't have to put him on. He was going to be because look, the reason that we put witnesses on is to get evidence in. Like that's the reason we do it, whether it be statements that they've heard, evidence that they collected, portions of the investigation that they actually are the ones who had done it. But the purpose of putting a witness on the stand is to get evidence in, whether it's testimonial or it's physical evidence, one of the two things. So if Lally's able to use BUKHENIK here to get in all the evidence that he needs, which he used, he got in a ton of evidence through this guy. Like I really felt yesterday coming out of it that he just cleared the way to not have to put Proctor on. And this right here, this line of questioning right here is exactly when it became absolutely imperative that Lally, it went off in his head. I've got to call him. It happened right here.
Well, all we know is that as of yesterday, it was officially said that he is
today, after this cross-examination.
Right, but we don't know that.
I'm just telling you, man.
It did seem like they were laying it out to not have to call him. That I think that seems very evident. But maybe it's just.
Let's just hear it out. I disagree with you. I mean, well, like I can't know. Like I'm not in Lally's brain, and I wasn't privy to the conversation. But I've been around long enough that I have the feeling we'll agree to disagree. I think they want to put Lally on or a Proctor on like they want a fucking hole in the head.
I agree.
That's how much they want to put Proctor on.
So I just,
and it's not for the shit, the gross shit, you know, searching for nudes. It's like, how is he going to answer the question that, okay, you know, the whole thing with the gift, like, why are you buying a gift? Oh, give it to my wife.
Coming up with it. He's been working on it.
Well, I mean,
But I want to mention, first of all, I'm sure, I assume that's saying what's happening.
what happening?
The later it gets, the worse my eyes work. We're old.
It's like my tongue. My tongue is barely functioning at this point.
Go back in that interrogation, Karen mentions the beating. How much weight will that hold in the long run? Well, they actually excised that out of her statement and it wasn't mentioned. Now, there's something called the completion doctrine. It's something that allows if one party uses a portion of a statement in order for you to be able to say, well, you got to have the whole context, this, that, and the other. There's something called the completion doctrine where the other side can insist they put the entire thing on. And this goes to the point that Bob made earlier. It seems like this was the judge's decision. She did say she was going to go home and think about how it was going to get handled. And it seems to me clearly the defense would not want that in. They would want that in, that it was the judge's decision. So, the completion doctrine wasn't on the table, but they might still try on their cross, or they might have objected, or maybe they'll ask during their cross, can we, under the completion doctrine, can we put the remainder in, and then let the judge say no again, just so it's on the record. But that portion of what Karen said was not played in front of the jury.
Okay, let's go.
Ali asked you about February 4th and February 10th, very specifically. Both of those searches you were involved with out at 34 Fairview, correct?
Correct.
But Sergeant, you didn't personally write a report about your conduct at 34 Fairview on either of those 2 days. In other words, you didn't go back to the station and generate a report yourself.
I don't recall doing that, no.
There were no photos that you took of the items at the location.
I did.
Most of photos, correct?
I did not take photos of the items.
Okay. And the first report that indicates anything that happened or was recovered at the location on either February 4th or February 10th, that was first notated in a report dated November 4th, 2023, year and several months later, correct?
If you say so, I do not know the exact date. That report would have to be presented to me.
May I approach?
Yes.
See, now, if you're not
You don't have to read the whole thing, but if you can.
fervent court observer, this shit is boring as hell. What this is brilliant maneuvering by Alan Jackson, ensuring that the Commonwealth has to call Proctor to the stand. They do not want to call him as their own witness, where they're having to ask him, direct him until he's just fighting them so hard that they have to ask permission to treat him as hostile. They don't want to do that. Like, if people are out there thinking, oh, it'd be great if the defense called, it would suck for the defense. It's very difficult to do. Like, you want to be able to cross-examine the witnesses. And Allie and I were talking about it yesterday, like the concept of like, what does Lally do? Like, because technically he's crossing.
Right. It almost would have been better to just, if he hadn't caught him, which he is now. And you know what? I've started thinking about it some more. I think you're right. He probably had to tell them at the end of the day, who he was going to call the next day, and say if he was going to call this guy. And he was probably leaving it as hoping
maybe
as much in as he could with this, right? Because he started off the testimony with Proctor as well, and the judge, there were a lot of objections to the judge not letting him get too far into anything that Proctor did, despite all of his
and we know that the Canoni is of the mindset, she said it in that hearing. What if they don't call Proctor? That's when Jackson said, well, we will. We know this is out there. We know that even the judge, and just through reading the pleadings leading up to trial, knows that Proctor is a giant issue for the Commonwealth. And it goes to like what you're talking about, like how brilliant it was for Jackson to not ask the leading questions, to leave it open-ended, where he has to say the words that has to come out of his mouth. Who did those? Who wrote those envelopes? Proctor did. Where he's saying it, it's like, it's just a very well put together cross-examination by a guy who really knows what he's doing.
Jimmy, sometimes the lead detective does have more ability. Like in a federal case, the lead agent, I mean, he's basically like a second prosecutor. He's like he's sitting there, he stays in the room, but under the collective knowledge, if they work on it together and he's reviewed all the documents, he can speak to things that other officers did. So I don't know, but and he may be more involved in things, so that might give him the ability to testify to everything. But yeah, I think that this sergeant could testify to anything that he was involved in, not just something he like read about later, but he was actively involved in as he has done. So when the lead detective is more actively has his hands in more things, that does give him the ability to testify to all the facts, because he also might be saying, well, then after every day I did, I had meetings with all the other officers, we talked about what they did. So
Right. And Jimmy, just keep in mind that they can do it, but it's not preferable. And remember, the only people that matter in this case at this point are the 12 people in that box and however many alternates they have. That's all that matters. And you have to be thinking about that the defense has been leading the jury down this primrose path of this guy Proctor. You have to think about in reality how that's going to affect this jury if they don't put that guy on. It is going to leave a big, giant, gaping hole and question mark in the minds of every juror. Like, where was this dude? And why didn't he testify? He's too big a part of the case. It's so long ago that we forget about all the shit that was coming in, where the defense is trying to establish the relationships that the Proctors had with the Albert family. And, they're in weddings and ring bearers and all that shit was laid out to make Michael Proctor, whether he is in reality or not, an absolutely critical piece in the investigation. And that's like in the defense was able to do that, whether it's real or not. Whether if Proctor was just telling other dudes to do shit and wasn't doing anything, then the defense has done a masterful job in creating their narrative. And I say it all the time. The state wasn't there. The defense they weren't there either. And what we're talking about are two sides that have created their narratives based on the evidence, and they're trying to sell it to a jury. Now, in the search for truth, that should make your stomach drop, because we don't get it a lot of times, and this case could be a perfect example of it. I don't know. So I just want to be clear. When you're calling it the interrogation, you're talking about where the second time they arrested and answer in the chat, Orange Tabby, and thank you for the $5. You're talking about the time when Karen's taken into custody and charged with second degree.
No, they're saying that they actually played the part about the fight in there, and I thought we rewound it.
Well, but he says John was demolished. It's very short. It's all there. We played it
I
twice.
thought that there was a part before. Maybe I'm thinking of something different. I thought there was a part in that statement when they played it pre-trial where she said they actually beat him up in the house.
No, she says John was demolished in that house. It starts with,
yeah, I heard that.
We're playing the same game here, right? Or we're all in on the same joke. It's that we played it three times here.
I just thought that there was another piece that I thought they didn't put the whole statement in.
They didn't, because there's much more conversation where he then tells her, oh, well, you should probably follow the law, and you should probably stop speaking now.
Right.
He tells her that. This is when he's there. It's not an interrogation. She was being processed.
Right.
So
I thought she said something even more about a fight in the house than what was played.
I think it was relatively. I mean, we could always go back to the hearing because they played the whole damn thing at the hearing.
Right.
But for this, it was like a 4-second, 5-second statement, a couple of statements by Karen. And that, just to be clear, it's not an interrogation. That was not an interrogation. It was literally the cop that was processing her in
Right.
on the
And we
second
did
degree
play
murder.
it earlier, and I was under the misconception in my mind, and I was asking about this earlier, Bob. Was there a
Pulverized. Thank you.
was
That's
there
exactly what.
not something else she said about a fight in the house, the word fight in the house being used that wasn't included? And I guess it wasn't. There was nothing more, and they put all that portion in.
But we did like so. I think Charlie Lanza, like we didn't hear that today. That Colin and Brian beat him, right? Like
That's
I
right. I feel like there was a piece missing. Am I crazy?
so correct. So she did. No, you're not crazy. There was much like that was a very truncated version of what we heard at the hearing preceding the trial. So but you guys like we did not hear that. We did not hear this portion today that she says that Brian and Colin, because it starts the clip, we listened to it twice today. Like it starts with you're in on the same joke, right? Or whatever she says about the same joke. And then she says something about my taillights cracked and John was pulverized in that house.
Right. That I heard she said today.
Well,
Correct.
that was it. Like there
Okay.
was no more of it. Like I rewound it and played it twice against your wishes because I wanted to hear it again. So I don't think, just confirm, like that we did not hear this portion of it, but it exists in the world.
That some people are saying, yeah, and it seemed like some
But
people.
the part about the fight was that John was pulverized in the house, and that's it. Like this thing that I just had up on the screen that Colin and Albert beat John up was not in there today. Don't make like if somebody gives me the time, I'll go back to it. This is today's testimony. All right.
And I'm gonna have to find the original one because you and I did a thing on it.
Oh,
So
people are driving me nuts. Okay, so in the overall statement that exists in the world, yes. What I'm asking is that doesn't matter in terms of evidence. I want to know if that portion, Brandy, was heard by the jury today in that tiny little clip of it they played. I didn't hear it.
was
So,
that today or was it yesterday? It was today. Yeah.
yeah, it was today.
The car, the ring camera, the pictures, the snow. Where's my note?
Christina says that was played today. Now I want to go back and hear it.
Okay.
See, that's why I wanted to go back and listen to it. And you were like, no, I don't know. I want to hear that. But just be clear, it's not an interrogation. It's that part is.
I think it might have been yesterday.
Was that yesterday?
Yeah, it was yesterday. I'll pull it up. I have it up over here.
All right. I just want to. So Allie will pull it up because I do want to hear that again. Because I'm not catching that part of it.
They just said it was today. I'm going crazy through my notes. Let me see. Today.
I think it was today too. I think it was
towards today. So it says ring camera, February 3rd, pictures, snow, glass, February 3rd, ring camera. Oh, audio joke. Jesus. 1:26:14.
All right. So I'm at 2:05. I want to go back and hear this. So 1:26, what?
1:26:14.
Okay. I'm slowing it down.
Oh, maybe
We're all on the same joke, right?
Maybe there's a little.
Pulverized.
Rewind it. Maybe I missed it.
I am.
Sorry.
I'm slowing it down.
We're all on the same joke, right? My tail is cracked and John is pulverized.
I thought she said more.
Okay, where did she did not say Colin, like I just played the entirety of it.
Right. She did originally.
Oh my God. How many times? Yes, that exists in the world. The statement, we heard it all during the hearing. That's not evidence in this case.
On hearing that statement, what, if anything, did you do?
Oh my God. Like, I feel like I'm in crazy world. All right. Did somebody hear Colin and Brian right there? Because I just played the whole damn thing.
The audio is
the Brian part was there today. Oh, I don't know. Okay. Rewind further. Okay. All right. Maybe there's more of it they played. Maybe you had me jump to.
That's what I'm saying. Maybe I started too late.
All right.
And that she made it voluntarily, freely, and rationally. In
Okay, so
determining
she's-
whether the statement made by the defendant was
She's giving the
voluntary or
limiting
not, you
instruction.
may consider all the surrounding
Did
circumstances.
you guys like this
These
too slow, or
include
was
when
it
and where the
crazy?
statement was made, the nature of any conversations with the police, or any questioning
Am I
by the
getting
police, the
sleepy?
defendant's
Yeah.
physical and mental
I've been on
condition,
live
including her
7:45.
intelligence, age, education, experience, and personality. Your decision does not turn upon any one factor, and you must consider the totality of the surrounding circumstances.
All right, here we go.
Here we go.
With the court's permission, may we publish that for the jury at this time?
Yes, do you want to turn off the air conditioning? Is this very short, right?
It is very short, and if we could, please, yes.
Oh boy, this live is one for the books. All the people missing it.
And
Just
this is just audio, correct?
shutting it down.
Don't talk. I want to
Okay.
hear it.
Okay, you're aware that you speeding up at Brian Congress.
There it is. Everybody's right.
We're all in on the same joke, right?
I gave you the wrong
My
timestamp.
tail is correct. and
Sure
John
did.
is pulverized.
And when we rewound it, watching it
I'm sitting
live,
here berating our subs because you gave me the wrong timestamp.
right, but
Physical
when
and
we,
mental
when
condition,
we watched
including
it
her
live, pause it a sec. When we watched it live and you said you wanted to hear it again and rewound it, you rewound to the same part.
Well, because you gave me the timestamp.
No, not while we were live. I'm talking about when we were live and you rewound it to listen to it again. And I said the same thing live. I was like, wait, I didn't hear the part about the fight and getting beat up. All right.
All right, what do I want to hear it one more time?
Sorry. Can we delete the last 10 minutes of all your guys' live?
This is live. This is the point of live.
Oh Lord. I think we don't post this after this.
Oh, please. I
And
mean,
this is
everyone was
just
telling
audio,
me, and
correct?
I blame you.
Yeah, I blame me and I blame you.
What? How could it be my fault? You
On the
gave me a
live.
timestamp.
On the live.
You don't remember the live from
I did.
7 hours ago?
I remembered
Okay,
thinking,
you're aware that you speeding up at Brian Congress.
yes, there it is. That's the part
Yep.
that
We're all in on the same joke, right? My tail is correct and John is pulverized.
I mean, how does the, like, we thought, how, like, why does Lally want that in?
because what are you talking? Oh, Lally. I don't know because he's trying to make it sound like she made some kind of admission there. He's
Right.
making it sound like her saying, like, my thing is dented and his head's pulverized, as if she was saying those two things go together.
Okay. All right. So, but my point is, we all listen to it.
Right.
Like, where does Lally, where
Yes.
does Lally come up thinking that no court tomorrow? I'm definitely sleeping in tomorrow because it starts for 7:45 for us in the Midwest. So it's early rising with this stuff. But like, I can't understand in what world he thinks that helps him. That's not an admission by her. It's her saying that John was beat up in the house by Colin and Brian, that my taillight's cracked and John's pulverized. I don't know. Like that.
All right. So just in case anyone didn't get it, I missed that first part, thought they didn't include it, and that's
And then I yelled at everybody for being crazy. I thought everyone was gaslighting me. I'm like, is everyone gaslighting me?
we were gaslighting them.
Yeah, right. Exactly.
I really don't like when you use the word wrong, and I shouldn't have played into that. But
I think that was correct usage.
not correct. That was just a mistake.
You do know I don't really understand.
I'm not going to ask you to open those. Don't worry about it.
All right, so-
At this point.
All right. I think what we do, I mean,
Just go to the end.
oh my God.
Just
Like,
do
I want to
it.
hear all of it. Like, there's so much good shit. Like, how do we skip the tire? You can't skip
Oh,
the
no,
wheel
you can't.
moving.
Higher. Oh Lord, no.
That's what I'm saying.
All right, start here.
The last 20 minutes is banger shit.
In the area,
Five.
Okay, what does area mean?
it's a location, specific location.
Are we talking about, because we do this all day, I guess, are we talking about an area of 5 feet or an area of 50 feet?
Based on where the items were recovered, we're talking about an area approximately of 30 square feet between the roadway into the grass.
All right, he's still
It's
talking,
We saw photographs.
talking about collection. We're going to the wheel.
I mean, it explodes, right? It goes 30 feet.
It would
30 square
document
feet.
the exact location, correct?
And you did not do that with any of these items, correct?
No.
The
'cause we-
items that were not photographed were not also GPS located, but they were within the same vicinity of where the other items were collected.
But again, now we're back to the
Look,
same
you guys
question.
show us. Look like 50
Your
people
word
left
of
like
vicinity
you.
might be different than my word.
Huh?
of vicinity.
I was
Right?
kidding.
Objection.
Sustain.
When you recover these items or any other items, it's obviously important to memorialize on the evidence bag or in some other way exactly where they're found, who found them, the date, time, etc. Correct?
We do the best we can to document all known information
That's important.
on each evidence
We're
item.
going to the wheel.
I would have to see the bag.
Can you ask space to enlarge it?
If you can enlarge it, please.
Just-
Hey. If he enlarges it enough, you guys can see that the date of collection is a
Well,
separate.
you can see it right there. It's 2/10/22. But like, so Jimmy McNutty came back and he said you were right that what's her face did mislead because it clearly says date of collection. Like I wrote, and then I'm like where you were like, this isn't up for debate. It's right because it's date of collection and the time it's collected. Exactly what I had written in the that's how you create a chain of custody. Trust us, we know. We're actually criminal defense
Some
attorneys,
things. Don't.
not civil. Like we're like we do criminal defense work. See these things all the time. All right. I'm gonna keep plowing forward.
Please.
I can't even hang my I can't even hold my head up after that failure to miss the first 5 seconds of the recording.
I mean, my favorite part about that statement is it's not some kind of confession. It's weird.
All right, here we go.
Pull that up and then I'm gonna ask you.
I'm assuming everyone in here has seen this, but if not, you're up for a
Can you just
deuce.
play that for a quick second? No, that's good.
Spoiler.
Pause. Does that
Thanks,
appear
Melissa.
to be, I'm just pausing it in the first 2 or 3 seconds. Does that appear to be the video that you saw yesterday?
It appears that way, yes.
Okay. Mr. Bates, if you could enlarge the area around the right.
Master Bates is going to do the enlargement right now.
Of the traverse.
Oh. See, this is why they wanted
I'm
this
gonna ask
guy,
you,
their own AV guy.
Sir, if you'll
It's
pay
huge.
close attention to what's been zoomed, and when the SUV gets close to it, I'm gonna pause it and ask you another question. Can you go ahead and play this?
Objection.
Object to this.
So why don't we pause the screen,
All right.
take it down, and I'll see you at sidebar.
Why
All
not?
right, so here I want to ask this with all this shit, when like everybody's been going nuts on this case for the last year, has anybody seen anybody do this? Like I've spent so much time looking at that stupid video, like arguing with Allison, like it moves, look, see it move. Like, has anybody thought to do that you guys are aware of out in the YouTube worlds, on TikTok, anywhere that has done that, where they focus on the tire, where you can actually see the tire move? Because like it blew my mind today. It blew my mind today.
But also in our defense, we don't have the raw video. Like if we had this in our office, we'd be zooming it up and, we'd be slowing and, we would have found that shit.
For
Sure.
sure. I like to think you're right, Bay. I like
But
I like to think you were like we would have said, we would have been so obsessed with that portion of the defense that it's critical to them. It's
Right.
critical that her vehicle, in their theory, that her vehicle hits his vehicle.
It was like the time we found our client staring at the police watching in during surveillance to prove that he knew they were there and he didn't blow their cover, so he's not responsible.
Wait, you're telling me Lana did that?
You and I did that.
No, I'm telling you, somebody said
Oh.
Lana from Truth and Transparency did it. I should have known.
What?
Dude, she's on top of her shit. I told you that.
I know
Like,
you have
Lana
that.
don't fucking play, man.
Right.
When she digs in, she digs in. I told you, man, Lana's the one that wanted us to handle that case, like to go handle that civil case
No,
out in Idaho.
no.
All right, let's go.
Go ahead and enlarge that, the rear area of the traverse. And I'm going to ask you to pay special attention to the back wheel and any movement that you may or may not see.
Truth and Transparency, people, check it. She's on top of her game.
Oh, dude, there's no doubt.
In about the next 3 seconds, Sergeant, I'm asking you to pay special attention to the wheel. Go ahead.
Oh my God, it's so fucking evident right there. It's like,
I know.
did you guys see it?
We
Like,
all saw it.
The first time I watched, I was looking at the snow. I'm like, oh, all the snow is gonna fall off the tire. Like the tire, the wheel itself moves. It's unbelievable. It ends that the whole controversy's over.
Over.
Special attention to
I'm not trying to cut us
the back
short.
wheel and any movement that you may or may not see.
Short. We've gone longer than the trial day.
It's true. We actually did go longer than the trial day, y'all.
There needs to be a recap for the people.
Watch it. Watch.
In about the next 3 seconds,
Oh, Lord.
Sergeant, I'm asking you to pay special attention to the
Now
wheel.
we're just doing it twice. Might as well bring Jay in.
Oh my God. Oh my God.
I mean, we don't know that. How does
Can you
Jay
do that?
says, well, she did.
Sergeant, were you able to see that?
break the light.
I know it's
We
not
don't know that.
in the world. Were you able to see that video okay?
Yes, I
What did
did.
you notice about the rear wheel of the Traverse?
See me, you
Based on the
couldn't
motion
possibly
and
know
the-
that. You couldn't possibly know that,
In the
man.
shot with the snow
Their
falling,
little Zoom
um,
trick.
it appears
We would have seen
that
shit
there is movement, but the
All right,
video,
wait,
it
you're-
appears,
You're
The
talking
rear
over
wheel
his
of the
admission.
Traverse thing in the world.
All
Were you able to see that video
My
okay?
favorite part.
yes, I
What did
did.
you notice about the rear wheel of the Traverse?
Based on the motion in the shot with the snow falling, it appears that there is movement, but the video speaks for itself.
What would you assess based on the movement
Now
of the rear wheel of the Traverse about whether or not the two vehicles came in contact with one another?
Objection.
Sustained.
Okay.
Here's the fairest question in the world. Calls for speculation? No, it doesn't. You just saw the goddamn tire move. Doesn't call for speculation. And he said that.
No,
Just
I
a
don't
moment.
think she was doing it for that reason because it
What,
doesn't.
what was the objection? Since we don't know what the basis, what could be the basis be?
I
He just
think
doesn't
she's-
want to hear him answer the question.
Right. I just think she's.
Objection. I don't want him to say the answer. Objection.
I don't know.
All right. So let's go to the last banger. Like, this is the shit that the jury's going to be sitting on for 4 days now, too. Like, Lally can't be thrilled about it.
And I think runtime 120.
Hey, and if you want to see the whole trial day, Bob and Jay did a stream, actually me too, of the full trial day. So
You do it every day. Every day.
just rewatch that.
Yesterday, I was on for 12 straight
Do you
hours.
recognize that as the video we saw yesterday?
Yes, I do.
Oh boy, here we go. Here we go.
Babe, did you figure out dinner?
I went up and got cheese and pepperoni and turned the camera.
Very briefly,
I
if
was
you could
dying.
move to time of day, 5:37:05.
Did you hear Aunt Bev like unscrew the lid of her water glass and crunch some ice there? Classic Bev.
He's like, this
When we were live streaming today, I thought it was you. 100%. I thought you like, cause you'll eat ice. You're known to eat ice.
yeah, I try to hit the mute button.
All right, cleaning there. Oh, there's the guy getting in the driver's seat. Oh.
With the court's permission, can we play at this point?
Yes.
All right, that shows the vehicle coming into the Sally Port, and we're looking at which side of the vehicle?
So that is the driver's side of the vehicle. What that video depicts is a mirror collection. Although mirrors are accurate representation of what you're seeing, it's just inverted. So that is the driver's side of the vehicle. I do not know why it is inverted, but that's the way it was presented, collected and presented from Canton Police.
Can you see a timestamp or a time and date stamp on the bottom of that? It's in blue.
I cannot know.
Does it appear
I think he could have said, Your Honor, for
that
the
time and date stamp, if you can't read every
Time and
letter
date
on it, that is in correct order? In other words, that's not inverted.
I cannot read it, no.
All right.
T probably just got off a marathon live too.
She was probably doing Rex.
T does some marathon live, man.
Hey, so this is your recap. It's much shorter than the real trial
I
day.
do not know.
Yeah, I promised
think
Darren
that's
that
the
these
tow truck
recaps
driver.
would be
He would
an
have
hour.
the only access to the vehicle.
You
We
can't-
did not touch the vehicle.
Who's that on the left?
I missed that. I was looking down
Look,
at the
look
laser
at Proctor
pointer.
back here.
I do not know.
That's
I know
see Proctor back
for a
there.
fact I'm the gentleman that's wearing a.
All right, you see the dude's head back here. You see the guy right by the tail light, right back there.
View is him. So remember, I said on direct, he said he did that little like slip and fall, and Lolly asked him, "Who are these two people?" And he said, "That's me, and that's Proctor." Now he's saying, "I don't know who these people.
I
are.
don't know who these guys are.
Who the hell are these guys?"
I don't know. It's not. This is not helpful for the Commonwealth. So there's Proctor there. Let's watch. See where he goes.
We did not touch the vehicle.
Who's that on the left?
I
Gonna
missed
hang
that. I was
around
looking
over
down
here.
at the laser pointer. I do not know. I know for a fact I'm the gentleman that's wearing a dark olive drab state police baseball style hat, and Trooper Mike Proctor is wearing a winter hat.
Trooper Proctor's wearing what?
A winter hat.
Over there.
That
By
part
which-
just moved. That was playing. I didn't realize it was playing while you were talking.
AJ wanted to rewind it there for him.
Yeah, I wanted to have him pop out again.
So that is that dude getting in. So
He's
you
winning.
got.
Now because they're playing it in reverse right now.
I know,
Oh,
but that's not BUKHENIK
So,
or BUKHENIK or whatever.
and that's Proctor.
That's Proctor.
yesterday, when you testified,
I
you
don't
indicated that the two individuals in this scene were you and Trooper
But a
Proctor.
third
correct?
dude appears.
Not correct. There was two individuals in the rear of the vehicle. I
Oh,
shined my light to. That was me and Trooper Proctor.
You see Trooper Proctor toward the back of the rear of the vehicle there?
I can't tell because of what the head is. I just know that Trooper Proctor was wearing a black hat.
Which the person in that, in the video to the left, to the rear of the car is wearing a black hat, correct?
I can't tell. I don't want to
Remember
be
that-
locked into a statement where later on you show me that it's somebody else magically. I can't testify to that.
There's no magic about this. It's your testimony. I'm just asking you what you see.
I
I
think that's
don't see that. No.
outro tonight.
Oh, thanks, T.
Hi, Teresa.
So,
See,
let's go ahead and play this.
you see how that dude magically appears?
Boop.
Wait,
Bop.
are we nuts? Are there three people? What is that right there? Wait, watch this again. I
Do
gotta
you see
slow.
the person
I wanna
toward the
slow
back
this
of the vehicle walking toward the opposite side of the SUV?
I do.
Jackson's gonna do it, babe.
What area does he appear to be going to?
All right,
It
go ahead.
appears to be going towards the rear passenger side of the vehicle,
Well,
although
he just had a stroke.
it does not appear so because the video is inverted, a mirror image. That's where he's going.
And Sergeant Buchnick, you testified for,
I'm sorry, it was a long day. I don't know the timing of how long I testified.
you significantly testified about this video yesterday, did you not?
I testified about this video.
And you testified that it was true and accurate, correct?
Correct.
You testified that it was reflective of your observations of what was happening in that Sally Port that evening, correct?
What you doing? Why are you
I
stopping?
testified that this is a
Huh?
accurate
You slowed it down and make us watch the video. Now you're just having them
scene
talk.
and collection of video evidence from the
Sorry,
Sally Port.
And as that truck sits in that Sally Port, just like this, it appears from all perspectives that what we're looking at is the passenger side of the car, and that right rear taillight is right there shining in our face, correct? From this perspective.
Never know what you're gonna get with us, you guys.
I'm sorry, can you repeat the question?
From this perspective,
Oh,
the perspective that the jurors are looking at.
Okay.
From all
Question never
indications,
gets
that would
easier
appear
to
to be the right side of the truck, the passenger side of the truck, and that taillight that you can see is the right rear taillight from this perspective, correct?
The way it presents itself, yes.
And yesterday, during the entirety of your questioning by Mr. Lally, not once did you mention that this video is actually completely inverted,
I
correct?
did not know.
Mr. Lally didn't ask you if it was inverted, correct?
That's correct.
And if
That's
I hadn't gotten up here and begun questioning you, that would be left uncorrected, correct?
Objection.
Sustained.
The person with the winter cap appears to walk directly to the what ultimately should be the right rear taillight of this car, correct?
That's what I'm
That's
talking
the
about,
vicinity,
Aaron.
yes. That's where he is. Yeah.
The third person that time travels. It's so like there's like shit missing. Oh wait, this is the shit. Like this is where I want to slow it down. Like as soon as this dude closes the door.
Pause it.
No, this
I'd
one's
like you to pay attention to the right rear of this car. And I know we're completely backward, but it's the far corner of the car. Do you see a person's head there?
It appears as if someone's still there.
And that person is located at or near what portion of the car?
this isn't the part, Bev.
That- Yeah, it is.
In real life or as it's depicted?
it's so
Is the
different. He's
person
got a
near in real life, near the right rear taillight of the car.
Yes.
He's calling this
Matter of
the
fact,
passenger side. He should-
standing there hovering around there, correct?
We don't know the distance that they are in proximity to the actual vehicle. We just know that they're behind the vehicle. That
Looks like it's pretty close, doesn't it?
Objection.
Oh boy, people are still talking about the fight.
Does that look like he's in close proximity to the right rear taillight?
You can hear like he's
as I said, I can't tell how far away he is from the vehicle.
It's right there, sir.
It's like
You can't tell me it's right next to the right rear taillight?
Objection.
Sustained.
I want you to pay attention to what that person does as soon as the other person comes out from behind that car. So you see him
Okay.
move.
tell me what he does.
Stop it.
look.
Do you see that person move?
Do you see that fucking like the third dude pop up right
I
there?
saw movement in the frame, yes.
Right when the other person
Did you see it?
is
Hey.
in eyesight.
Watch.
I saw him.
Stop it.
Where did that guy come
Do you
from?
see that person
What you're
move?
talking about? The whole.
I
most of the
saw
time Andrew
movement
knows
in the
about that
frame,
guy.
yes.
Right?
What?
You're talking about literally when they were going in reverse, like a video, like minutes back that you're
No, I
talking.
know, but it's that same specter, the same ghost that appears. That this guy with that yellow shit right near him, like this third dude who was
I don't-
nowhere to be seen up until this moment in time. I mean, it's proof that they doctored the video. There's portions of it. You
I
see,
can't
you
tell
see this third guy, right?
Well, I don't know if he's the third guy.
What are
He's
you
in
talking
eyesight.
about? Oh my god! Do you guys see the third? Wow, boop! Right there.
You see
Here's
that
the
person
second
move?
one.
Oh my god! They're all right. Here, listen.
I
Listen.
saw movement and
Okay, you get Proctor's head is still by. Can you blow it up? Blow it up for yourself. Make it bigger on your screen.
All right.
Proctor's head is still there. By
Where?
the tail light. You see
Where?
that? Okay, it's the round thing behind the Lexus. Did you blow it up?
I did.
Okay, well that guy's gonna like very clearly walk. So the dude who was in the car has now
Oh,
walked out of the
That's
garage
the third
door.
guy. I didn't even see this head over here. I don't.
Okay,
I'm
well
not
that's what I'm trying to
even
tell you.
head.
You missed a pretty
It's
major
like
part of
by
the
the
video.
door. It's in the door frame almost.
It's closest to the right side of the garage door, and there's like a yellow thing on him. You can see he's like
Well, I see that guy.
right. The
Where-
other guy walked out of the garage, and the third guy is just a head, the top of his head, standing right by the tail light.
That's what I'm asking you. Is he in the door frame? The head is in the door frame.
No. Oh yes, he is.
Okay,
That,
all right, then I
but
got
I
him.
thought you were talking about the garage door frame. So the specter, the
The
ghost.
specter, I see that guy.
Okay, so that's the third guy that
All right.
appeared out of nowhere.
I didn't see the other guy. The head. I got to get some glasses on and
You
relook at all
blind
this.
as hell. You blind as hell. All right, let's
Oh
go.
boy.
in the frame, yes.
Incredible.
Right when the other person
You all love us.
Watch now.
It's in
Proctor's gonna
eyesight.
walk over.
of the person toward the right rear, correct?
I mean, the video speaks for itself. I
Video
Yeah, it does.
for itself.
yeah.
Objection, Your Honor.
The objection
Right,
sustained. No commenting, Mr. Jackson. We've talked about that.
I'm gonna ask Mr. Bates to back it up because there's one other issue I want you to pay attention to, if you can, right at this moment or right before this moment, and that is the timestamp.
All right, he can't see the timestamp. See now you can see Proctor's head move there, right, Bay? Like when you bounce back and forth. See-
Yes.
See, boop boop boop. Spectre.
Why
There's
that? Is that a
there's-
shadow or a real person? The specter.
Okay, so here's dude walking out. It was a third dude that was back behind the goddamn car with him. It's crazy. Boop 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 boop. It's insane. I don't know.
Back it up maybe 10 seconds.
Where'd he go?
Right about there.
I'm not
mean,
sure.
I can
My love, what I'm trying to
Instead
tell you is
of
they
paying
doctored the
attention to
fuck
the
out of this
individuals,
video.
I'm gonna ask you, can you see, there, it puts the screen on.
This is what Jackson was walking up with the flash drive.
I know.
Like this is gonna be the mic drop shit.
It's the missing time right here. The missing 30 seconds.
We're gonna see where the specter came from. I'm assuming on Monday.
Oh, let's see. Hit play because he starts to say it.
5:37 and 37 seconds PM. Can you see that from where you're at?
No, I cannot.
Me neither. But I don't like to. Let's play it for about 10 seconds.
Oh,
Boom, man.
Pause it.
Saw him that time, right, Bay?
Did you see another person just appear toward the rear end of the car?
There was a fog of some sorts.
Oh my
I-
god.
It did appear as if a person was actually in, there was two people back there and two people walked away, or one person walked away.
Timestamp jumped to 5:38:01,
oof.
correct?
Oof.
I cannot see the timestamp, sir.
Oof.
Did it appear that there was an anomaly? There was a portion of that video that was deleted. Or it's missing, not deleted, but just missing.
Objection.
Can you tell that? Does it appear that way to you, Sergeant?
Yes.
No, Your Honor, I cannot tell what is happening with the video.
So glitch in the matrix. There, I solved it. Mystery solved. It was just a glitch.
Yeah.
Now we know. Glitch in the matrix. That's what,
Yeah,
like, that guy wasn't really there. Just a glitch in the, like, if you know, BUKHENIK was smart,
Eyes on the jury.
it's clearly a glitch in the matrix.
People be like, oh, yeah.
Oh, you mean the matrix glitch? Yeah, now I see that.
If you take a close look at, there's a classic police car in that Sally Moore, correct?
Did you just
There's
see
an antique vehicle there. Yes, yes.
somebody
Take
said,
a close look at the trunk of
Oh,
that
you-
vehicle. The word police.
You know what Yuri's doing? As soon as he walks out of the house, out of the courthouse, he's like, that motherfucker. Talking about Lally, not Jackson. He's like, that motherfucker.
he fucked me so bad.
Oh man, if you don't think that cops get pissed
Every
off at
turn.
state's attorneys that don't like, that set them up to look like total
Assholes.
douchebags, oh my
With the
god.
return of warrant for the activity log.
Oh my god. It's like the cops have to be furious with Lally. Just like, it's like, this is like way worse than him not fronting shit with like the Alberts and the McCabe's. This is like putting a cop up there
With
that,
an inverted
oh
video.
man.
Fog people. I saw a fog.
Yes, I believe I can read that. Yes,
And it's backward, correct?
it is mirrored. Correct.
That's a good indication that this is an inverted video, right?
It appears that way. Yes.
And if we were to fast forward at 5:42,
Now there's 4 of them. Maybe 5 or 6. I don't know.
Jimmy, man, I know you're staunch Karen Reed's guilty, man, but like, you got to admit this is fucked up, dude.
I mean, come on. Like, give me an answer that makes it. Let's ask every lawyer who's like saying words.
I mean, Lynn's asking, did the state
heard
tamper?
it.
Well, it sure the fuck wasn't the defense, Lynn. Like,
I
this is handed over to the
you see
defense
Sally
by
Moore
the
garage
state.
going down?
Yes,
You see a number on the garage?
I do.
Is that correct?
It's no.
What is correct?
Does the number?
All right, this whole the number 4 thing's insane.
Backward.
Like,
Sustained.
It's a mirror image by definition.
Sustained. Ask it differently, Mr. Jackson.
Your Honor, thank you. I don't think so. I would like to mark. I have a.
here it is.
We can bring the lights up.
This is the cliffhanger.
Wait,
Thank you. Thank you, Bev.
Somebody tweeted today that
I'd like to have Mark.
every time a cop lies, that cops outside play their sirens. It's like, you know, every time angel gets his wings, you know, you hear a bell ring type of thing. Yeah, so this is the, you know, this is the cliffhanger right here. The little flash drive.
does Mr. Lally know what's on this thumb drive without you telling us?
I do not.
Okay.
We can approach it. I can certainly.
Objection.
We're trying to wrap up our morning.
It's-
It's marked for identification.
If I may, Your Honor, I'd like to play the first 10 seconds of that video.
No. We'll come to something. It's marked for identification, right, Mr. Jackson?
So it's very typical to put on a video, play the first couple seconds so that the witness can say if they know what it is or not.
Right.
Because unlike the defense, unlike the state, we, the defense, can't sit with a witness ahead of time and be like, here, put this video on this disc. So when I show you disc 3, you can say, what's on that video. I mean, the state does it all the time, and it's just kind of easier. Like, yeah, we know that's what's on there too, but they're not doing the right steps. They're supposed to put it on, play a little. What is this? Is this that? Not just show them a blank disc. They could literally they could have swapped the disc out yesterday, but obviously we all accept as true, you know, when they're like, this 13 is this, right? Yes.
I'm just going to tell you, I know there's a few other criminal defense attorneys out there that have YouTubers, but like from a husband and wife team that has like tried too many cases together, to have this kind of moment, like in a case, is so rare. It's like, and
You
there's
had it once. You did that cop that planted the cocaine on the guy.
yeah, that was great. The cop was so, like, the sergeant who came in and testified was so fucking furious in the hallway. Like, I don't know if you had left by then, because that was a case where, you know, like my client, they said my client had blow on him, and like there was dashboard video, and there was like
There was a discrepancy in the video.
there was
I remember.
just a glitch in the matrix, and the jury came back not guilty. So you guys are amazing. You guys hung with us for 3:40. You had me screaming at you about interrogation videos that were played that I said weren't played because my wife gave me the wrong timestamp. So you guys
stand behind during the live. Bob didn't rewind all the way.
you know that I sleep through all the lives.
False impression that wasn't on there because I was like, what the hell? Where's the part about the fight? So
You know I'm sleeping, which I'm really just tweeting, but everyone thinks I'm sleeping. But you know, I'm live tweeting, so I clearly missed that. But look, I mean, this is setting up for a real banger on Monday morning, you know, and
our next recap, I promise, will be shorter than the day of trial.
I mean, I just want to pose this question to you know, the people, and look, I have a very difficult time getting to the vast conspiracy place myself. It's very hard for me to get there, like in terms of this being some kind of vast conspiracy. Like if this is a cover up, it's small. It's with, you know, the people in the house and like a cop, you know, but like, and I don't know if that's true. I don't know what happened. I still don't know what happened. But what I'd ask each and every one of you out there that's so adamant that Karen Reed is guilty, now that you're seeing the evidence and now that you're seeing this kind of stuff, it's indisputable. It's indisputable. Like if you want to sit there and tell yourself, oh, maybe the defense doctored the video, that didn't happen.
No.
This is evidence that was supplied to the defense by the prosecution in discovery. Facts.
They put it on.
You have to ask yourself that question, right?
They
put it on in evidence. You have to ask yourself that question. Why? Why are they doing these things? It's the like you have to be honest with yourself and ask yourself why. Why are they doing these things? You telling me the cops couldn't have figured out that Karen's car came in, or the Lexus came in contact with a Traverse? You telling me the cops didn't blow that up? You know, I mean, like they had to know that it actually came in contact. Yet, you know, he comes on the stand today and testifies that we did. Lally asked him on direct. You went by the Traverse. There was no damage. I saw no. You know, I mean, it's like, I don't know, man. It's like you've got to be honest with yourself, because look, the jury, they're like, none of us matter for a shit. We could bicker all day. The 12 people in that box are all that matters, and these are home runs for the defense. I'm just telling you.
If Lally would have had his witness testify that, oh, there was ever so slight contact made here, but we could tell, you know, like something, but for
acknowledge it.
Right. But for them to ignore it and then leave it as an aha moment for the defense is just downright stupid.
But that's like a dangerous path for them to take. They can't, if they're walking a very thin line here, the Commonwealth, because they don't have a lot of evidence. They don't have much physical evidence. It's a strictly circumstantial case. Let's just get that right. There's not one person in that house saw John O'Keefe get hit. So that makes it automatically where circumstantial. There's no eyewitness accounts. There's no video captured it.
It's not even as good as the tire moving.
Dude,
like, that's some damn
but
good.
that's what I'm saying. Like they have such thin evidence in their case against her that I don't think that Lally thought that it was conceivable that they could admit that her car struck that vehicle. Like it just gives
Why
it,
didn't he front the
because then
inverted
that
video?
becomes a reasonable explanation for the taillight being cracked.
Then why doesn't he front the inverted video thing?
Like,
Why doesn't he?
why does the inverted video exist is the real question.
The real question. I've never
Not
had
why didn't he front it, but why does it exist?
thousands of police videos. Thousands. Never has one been inverted. And Regina, that is she is speaking into that as to make the
We
record.
call it the elephant trunk on our live stream. We affectionately refer to
Instead of
she's the court reporter.
Describe it.
So
She's-
instead of using the the old machine, she speaks it in. So, but I think what I've heard is she speaks. We have a couple of court reporters, and I think Sarah may have said that I think she's speaking. Can you speak shorthand?
Yes,
Is
there's
that a real thing?
just develop a shorthand. She could develop her own, or there's probably one that's like kind of standard, and then people kind of tweak it and make it their own.
Yeah, I mean, this case, like, and I could see how people find this case boring, like just in terms of like it's really dragged out. But right now, it's picking up steam. It just is. It's like this case is picking up steam, and man, I want for the O'Keefe family. I've got no dog in this fight. I have zero dog in this fight. Like I want the O'Keefe family to get justice if it exists.
I'm
telling you, there is a world in which I think that neither of these things happened, and this was a straight up accident, and that the people in the house didn't have shit to do with it, that Karen didn't have shit to do with it, and
hit him.
Asha asked the question, then why, if he slipped and fell on my theory and a wild animal got to him and realized he was deceased, because wild animals typically don't eat dead animals. They'll kill and eat, but they they usually like fresh kill. But so like if he's already started rigor mortis, and the body's breaking down, like animals aren't into that kind of thing. So it's plausible. But my point is like, if they've landed on Karen in the early morning hours of the 29th, that, based on her saying I hit him, like, and I gave that the weight that it deserves, which is not much, because she says all kinds of shit and she's clearly distressed. Like, I don't consider that to be a compelling confession. Like, she was saying every variety of what she was thinking in her mind of what could have happened that morning or what that night. So
Amber's comment.
What was it?
Have you done that already?
Oh, Amber. I find it ironic that the presser for Rex. Oh my God, I love this. Thank you for bringing it back up. I posted this earlier, and I don't even know if Amber's still here. I hope she is. I did. I thought it was amazing. I find it ironic that the presser for Rex was during Trooper B's, pun intended, cross. It shows the stark difference on how the investigation should have went versus how it's supposed to go.
And you saw a very crazy. And you saw a very, why am I echoing?
I don't know.
A very good DA who's like, I'm not going to say more than that. I'm not going to speak to any of that.
Tierney's on top of his shit. I mean, like, if y'all, I tweeted that bail application. It's something else. It's something else.
I think you already thanked Joe Schmo.
Yeah, thank you, Joe Schmo, for that $10 holla. Bob, I finally watched your STS appearance. We had fun. I always have fun with Joe, and I love Josh. We've had Josh on our stream during our trial 2 or 3 times. He's great.
STS Nation, Surviving the Survivor.
Yep.
If Karen doesn't remember due to blackout drinking, editor Danielle Marie. If Karen doesn't remember due to blackout drinking and gives inaccurate facts about that night, is it the same as knowingly lying? No. And I take issue. And this is why I say I have a dog in the fight, because I take issue with things like that. When people try to make something like that into a guilty conscience evidence of a guilty conscience that they're lying and this and that, when they know damn well it's not a lie. And it's just like they did with the cup. Oh, when I interviewed her, she said she did not remove a cup from that first bar. And then later they put on evidence that she removed a cup from
Well,
the
like, but
bar.
here's the problem, and I'm going to play devil's advocate, because the issue is that unwisely Karen decided to do this Dateline interview where she contradicts herself. Like, if you don't fucking remember, then just say I don't remember. I know that's a scary proposition for her, because that means that maybe she did hit John and she has no recollection of it. Like, I get why that's a scary place to be for her, but like, to come and make these interviews, which I'm sure we're going to be seeing that Dateline interview where she's contradicting, like, they're gonna figure out a way to get it into evidence where she may, like, their statements against their impeachment. But there's no way she's getting on the stand.
What's LYK?
Lawyer, Peter.
I don't know a lot about all the different things. I'm out of the loop. And like, it's time for me to actually cut it short. It's actually time, if we can call it.
Wait, we want to call 4 hours short? Sorry, Darren. So like, we're supposed to be turning these all into podcast episodes, because we do have, this is the reason I started YouTube. We've got a pretty good podcast.
Yes, check out
With serialized, it has nothing to do with current cases that we cover, but like, the serialized stuff is pretty good. You guys should check it out. But thank you guys again for all the generosity. Thank you so much for hanging with us.
Doing anything tomorrow? Or are you actually taking the day off?
I am taking the day off tomorrow. I've earned it.
Oh yeah, Jay and Shannon. So check out the Shaming of Jay. Oh, what was the name of that other channel?
Hold on, I'm gonna look it up right now.
I'm sure one of our.
I'm gonna do it because it sounds like it's fun. So Jay does resale, like he has a separate like, he was gonna start a separate channel because he does resale stuff where he goes, finds little treasures, and then he's gonna do a live tomorrow, where he's like showing us some of his treasures. And, he's going to say what he paid for them. And then, he's going to be like, oh, and like, this is what he's going to look up what the value is. So it's like, I was telling him, I always liked Antique Road, like the Antique Road show. It was the same shit. Like, people would bring like antiques. I found this in my attic. It's been up there for 30 years. It's worth 100,000. It's like, I always love that shit.
Jay finds something worth 100,000 in his toy collection.
Yeah, I mean, like, it's like a treasure hunt, really. It's kind of cool. All right, so what I'm gonna do? Oh, so before we do that, I'm gonna find it. I'm gonna find what it is. But y'all, please share, subscribe, subscribe. It helps us so much, and it's free, y'all. It's free. You can help us. You can show your appreciation for us spending a lot of time really trying to put out some pretty decent content that we think has value. You can do us the super solid by just sharing, liking, and subscribing. It goes such a long way for us to get us under the algorithm, which I have no idea how that works, but people tell me that it's important, so I believe them. So
I thought it was Jay's.
All right, hold on. No,
she put it up. Spitfire did. It's now I forget what I already put it up there.
I didn't pull it down.
The Deals of Jay.
The Deals of Jay. Okay.
Deals of Jay.
Oh, that's a different channel. I can't portal to him because I don't know if he gave me. All right, check it out tomorrow. I got to tell him to add that channel. It's a whole separate channel. Like, Jay's got a whole different channel, but check that out. So again, thank y'all. We were 800 plus strong. It was a steady grow. I know I probably ate into some of T's audience, and I apologize for that, Teresa. I didn't know that you were going that long, if you're still even here. But you guys are amazing. Best chat in the land. We always stand by it. Our mods, talk about above and beyond. Our mods are unbelievable. We love you. We love you. We love you. All right, y'all. Thank you guys so much, because remember, without y'all, I'm just an old man.
Doing a hell of a lot of talking.
God, so much talking.
Talking.